Hi, Prof. and Otwa.
Good morning. Can you hear me?
Yes, I can hear you, sir. How are you?
Perfect. I'm very well. Thank you very much. And you?
I'm good. I'm good. I've made you a co-host already, so when your
Thank
time
you.
comes, you'll be able to share your presentation.
Thank you so much.
It's a pleasure, sir. Otwa,
Morning, sir.
how are you, my brother?
I'm okay, thanks. How are you?
I'm very well. I've also made you a co-host, so when your time comes, you will be able to share your presentation.
Okay, perfect. Thank you.
Okay. Hi, there is a participant named Richard, if I'm pronouncing it correctly.
Yes, sir.
Yes, sir. How are you?
I'm all right, sir. How are you?
I'm very well. Which organization are you from so that I note you on my register?
I'm with the African Procurement Law Unit with Professor Quinot, but I'm
Oh, you're
also
with Prof. Okay.
with a public sector collaboration forum.
Okay, cool. Now I get you. Thanks a lot, sir.
Thank you.
Hi, Lisa.
Morning, Mr. Mangweni.
Are you well?
I'm good, thanks, and you?
I'm good. Let me make you a co-host. Yeah, we just checking the sound as stakeholders come. So yeah, you are not late.
Okay, wonderful.
Okay, cool. Makatsi?
Good morning, Mr. Mangweni.
Good morning, ma'am, once again.
Yes.
I've made you a co-host already, and your
Okay.
sound sounds well.
Okay. Thank you very much. Thank you.
A pleasure, ma'am.
Recording in progress.
Good morning, everyone. The chairperson is trying to connect. Apologies for the delay, but he will be connecting in the next 60 seconds.
Not doing it.
Okay.
Well, I think it's unmuted.
Can you? To myself, yeah, it's unmuted now.
off the iPad.
Yes.
Welcome everybody. I apologize. I've been connected to 6:58. This has never before happened. We've been doing now for 5 years or more. Am I right? Neither the iPad, which I normally use, nor the cell phone, which I tried also, would unmute. Makes no sense that both devices refuse to unmute. So I have to go through.
Gerard, beg your pardon, we're really struggling to hear you.
Yeah. Better?
Yes, sir.
You can hear me now.
Much better, Chair. Thank you.
Yeah, look, this is astonishing. I don't know. What I tried to explain, colleagues, comrades, is that it's never happened before. Neither my iPad, which I normally use for Zoom meetings, would unmute, and nor does my cell phone. I'm going to try my computer, but meanwhile, I can't hold back this meeting. We have to finish by 1. And the first note to alert you to, apart from this IT problem, which I apologize to the stakeholders for, but it's beyond my control. I mean, it has never before happened, and it makes no sense that both devices refuse to unmute. So look, we are where we are. We will continue to operate. I regret to say that at 12 o'clock, I have load shedding in water systems in Tuesday. And sometimes my Wi-Fi works, most times it's not my Wi-Fi, my 4G works, my Wi-Fi goes off, so I remain connected. But there are times, of course, where the 4G, 5G doesn't work, and so Mama Rakhane, is she on the platform in Puleleko, or Linda Mox will chair, or somebody appropriate will chair, and it will have to be whoever in the committee. But we have to have this public hearing. So firstly, welcome to the stakeholders in particular, but everybody who's here. Colleagues, you know, and the stakeholders know too, I think most of them, that we meant to have this public hearing 10 days ago. The DA and the Western Cape Legislature said they wanted more time. We consulted with Legal Services Unit. They said, no, you're on course. You don't have to do it. You got the cycle of the NCOP, and so if you don't want to concede to it, you don't have to. It's a political decision. So I then discussed it with the committee secretary, and we decided, fine, we'll extend it for 10 days. Well, even though we did, people came to us yesterday and wanted extensions of time. They couldn't submit by noon. Yet, of course, this bill came to us, I think, on the 11th of December. So people well knew from June last year that the bill is in the parliamentary cycle. Fine, we accepted it, so there's no obligation, obviously, to do so. Secondly, I mean, you know, there are many, many claims about Parliament's lack of consultation. But as I've often said, oftentimes, it's actually a civil society that fails to participate. They don't get their act together. So, of course, people tell us, from the committee secretary, they want to appear at a particular time because they've got other commitments. Well, firstly, it's a Zoom meeting. They're not flying to Cape Town, nor are we are not living in Cape Town. We're not there. That's not an excuse. Thirdly, we can't organize a program based on the subjective views of subjective stakeholders with their subjective needs. We have to cluster the stakeholders. So if it's all NGOs, you cluster them in the first half, and then if it's business and related organizations in the second half, so that the discussion occurs around similar themes. Otherwise, we'll be too scattered. So no, we're not obliged to do that. And in fact, it's really quite presumptuous of stakeholders who've got such extensions of time to demand or to request even that they appear at a particular time. Well, if the person concerned is not available, a colleague of his or hers will be available or theirs. We've given more time than usual, but we want to stress that 12 minutes we know are not enough. But remember, we have a team in the staff and ourselves, particularly the chairs, who go through every submission as far as is humanly possible. Often there's overlap, so you don't read every line, I'll be honest about that. But I do go through the submissions, a substantial number of them. Now, there are many people who haven't asked for orals to appear before us orally to give us a verbal submission, but you will see at the bottom, Lelek was listed it. Now, to draw attention to both our editor and copy and others, as well as to Treasury and your team, that when you do a summary of the submissions, you obviously have to give the same attention to those who haven't asked to speak here and have only submitted written submissions. The next meeting date for this is the 8th of March. Am I right in Kulileko? Because from Tuesday onwards, we've got the fiscal framework and we have to finish that in terms of the legislative timeframes so that the appropriations and other matters can be dealt with between now and June, whoever is back here after the election. So there we are. I can't think of anything else to say except that Babarahani, you will lift up a chair if I cut off. Hopefully I won't be. And I know a lot of people are on their way to eThekwini because of the ANC's rally, and others are preoccupied with election campaigns. But this is an important bill, and we must give it the same attention we'll give any other Section 76. So having said that, Mpulileko, are there any apologies?
Only one apology from Mr. Tutoy. That's it.
I don't know what he's campaigning for. His party's got a voting seal in it. Oh, they might meet up into the DA vote. Oh, right, okay. Just ignore what I said, FF members and DA members are going out of order immediately. Let's move on. The first petition. Now, I have to manage this whole thing via the cell phone, which I'm not great at, but I think it's a chartered accountant. Now, look, please, can you put your cell phone stopwatches on so at about 10 minutes or so you begin to round up? Please, don't use the messenger. I don't decide, as I've said before, how many seconds in a minute and so on, right? And how many minutes in an hour. It's a scientific thing, and I'm just observing what the stopwatch is. Only you intervene if I have denied you, and I'm putting the stopwatch on now. Let me know, in Kulileko, who's here from the stakeholders, because I ain't repeating what I said at the beginning. Who's here? Are they all here, or are they just coming in when it suits them to slot into the times of submissions, verbal submissions?
They are all here, Chairperson. From SAICA, we have Mr. Benga.
No passing 12 minutes, please. And we will restrict our inclusive chairperson. I'll be very good about it. If it's 3-minute input, I will also observe the time, unless I'm pulling it all together at the end. But go for it, please. Chartered accountant, stopwatch will switch on as soon as this is the first one. It's 9:11 now. My God, 6 minutes behind time. So, go for it, chartered accountant, please.
Thank you, Chair, and good morning to you. Good morning to the members and the fellow stakeholders that are here. My name is Otto Benga from the South African Institute of Chartered Accountants, and I just want to thank you for the opportunity to present to you today on our submission. As a start, Chair, maybe just to say that we do welcome the bill itself, as it creates a single framework, right, for procurement within the country. I think too many times we've seen that there's a lot of documents that need to be considered, sitting in different pieces of legislation, and this is a welcome development, and also, Chair, the creation of the PPO's office, as well as a single point of call, is also welcome from our side, because now at least that we know that there's one person or one office that we can all contact as the institutions, whenever we do have issues with the procurement and the implementation of the legislation. Chair, I think just as a start again, what we want to say is that the procurement bill should not be considered in isolation to the current challenges, right, that are impacting procurement in the public sector. And those we group into 3 areas: resources and skills, I think we do see that there is inadequate resources within the procuring institutions themselves. And sometimes even when there are those resources, the skills that are needed to implement the legislation often lack. So the bill also take that into account. The existence or non-existence of an ethical culture within the environment itself, Chair, is also something that needs to be considered by the bill. The existence of an ethical culture creates an environment that is enabling to the officials to implement and do their jobs as required by the law, and also creates a platform for accountability to be implemented whenever there is issues with, a lapse of implementation, or when there's inappropriate, implementation of the law, and also allows for consequence management as well. And I think the AG has reported on this area quite a number of times over the years to say that there is a lack of consequence management whenever there is, a lapses in legislation and governance side, right? I think sometimes we do have, I think this comment has been said a lot, that we do have very good legislation within this country, but where then there's an issue, it's on the implementation side, right, of that legislation, and also the monitoring as well of that implementation. Obviously, the AG plays its role in terms of the audit side, but the procuring institutions themselves must make sure that the procuring institutions themselves must.
Right?
Sorry, I think there's someone who's unmuted. The implementation and the monitoring thereof of the legislation becomes an issue, Chair, amongst the procuring institutions themselves. Hence, we find ourselves having so many findings on irregular expenditure, fruitless and wasteful expenditure, basically a whole lot of wastage within the system. Chair, on the legislation and governance side, right, like I said, there are challenges in terms of the implementation of the legislation. Chair, there's someone who's unmuted again. So the implementation and monitoring of legislation is a challenge when those that are responsible for that implementation, Chair.
Yes, just explain. Finally, I am
Yes,
connected
Chair.
now to my computer. It's the secretary and myself. I mean, this is an utterly surrealistic situation. I've never heard of this, but here I am connected. So he and I have been talking. We have no other choice because of the absurdities of the IT, which we'll sort out on Monday. But now I'm connected via my computer. You won't lose your minute and a half. Go right ahead. Right ahead, please. Can you hear me? Oh, dear.
Yes, we can hear you, Chair.
Can hear you, Chair.
Okay, right. Go ahead.
We can hear you perfectly, Chair.
Good. Thank you so much.
Yes, so I was saying, Chair, the implementation and monitoring of legislation is a challenge when those that are responsible for that implementation, when there's not adequately documented legislation, right, thus reducing the accountability and effectiveness of the legislation. And the risk of non-implementation again exists when there's that legislation is not adequately supported by processes and policies, right? And therefore the legislation then does not meet its objectives. So what we are saying in our submission, Chair, the written submission, is that the duties, we do know that the duties of procuring institutions are included in the bill, but we must also include a requirement for consequence management, Chair, to be implemented where there's non-compliance with the Act that has been identified. We did not see a specific, clause that speaks to consequence management. Chair, also the responsibilities should also include that the procuring institutions, right, must implement processes to manage suppliers to ensure that there's quality services and goods that are being supplied to them. We do note that there's the department process that is included in the legislation, Chair, but there's still some lapses that we've identified in there through our submission, Chair, and the importance really of the quality of services being provided is, the HA reports on this every year. The MI process, I think last year on the PFMA, in the PFMA general report, they said 112 MIs have been raised on goods not received, poor quality, and the service is not in line with the contract. So, Chair, it is very important that the monitoring of the quality of the services is included in the bill. Then instances where this, where there's no quality services being provided, then the National Treasury and the provincial treasuries must be notified to blacklist those suppliers, Chair. And I think what, in addition to the blacklisting, is the step to make sure that the services, right, and the procurement does not continue while that process of blacklisting is being implemented. And also, Chair, the checks that need to be there to ensure that the person that has been the supplier that has been debarred, that has been blacklisted, does not just go and register another entity, another company, and they back into the supplier database again. So there needs to be checks. IT is very good in terms of making sure that those checks are there, and these are things that need to be addressed, Chair, as part of the development of the bill. On the skills and resources, Chair, obviously, these are key in terms of making sure that there's implementation of this legislation and the procurement process, right? Where the workforce does not possess the required skills, will obviously have difficulty in terms of the implementation, which may result actually in us not achieving any changes as a result of implementation of new legislation or even the current legislation. And also, Chair, we must guard against the fragmentation, right, in terms of the skills that are being addressed by separate legislation. For example, Chair, there is the framework on the professionalization of the public sector that is currently out being implemented, but that needs to always be intertwined and considered when new legislation is being developed, including this legislation, Chair. So the bill should definitely incorporate capacity and skills required in the procurement units. I think we touched on the fact that we need adequate skills, we need adequate resources, and those resources must be skilled. The responsibility, right, should be included for National Treasury to implement regulations on minimum competences for the head of procurement and procurement officials. Now, Chair, we do know that there was a time where minimum competences were identified and developed, especially from the local government space. But again, the implementation part becomes a problem. So the monitoring of the implementation becomes very important, and the requirement for that monitoring, the consequences when the implementation is not being done is very important and must be included in the bill. And the responsibilities of procuring institutions to ensure that those officials, right, in the procurement units have the required skills and minimum competences must obviously be there, and there must be the men and women that are able to do the job in those positions. Then, Chair, on the ethical culture, right, I think we do note that currently there's legislation in terms of the whistleblowing that is being developed and managed from the Department of Justice side, right? However, we must always make sure that, especially when it comes to the procurement side, right, that the promotion of an ethical culture is there and is actually being implemented, Chair, within the procurement units. And this is critical, Chair, because it also assists the public sector in terms of attracting the right skills, the right professionals to come and operate into this space. Too many times, I can say that some of our members as SAICA are not comfortable with coming to the public sector exactly because of sometimes the lack of an ethical environment that allows them to be able to do their jobs. So as we develop this bill, Chair, we must make sure that the ethics is key and ethics is quite prevalent in the bill. What we are recommending is a hotline, a fraud hotline, Chair, that can be managed by the procuring institutions, provincial treasury and national treasury, and that will assist in improving the internal controls around the procurement process, and to protect those that actually report the non-compliance with the Act. And obviously, this will assist in strengthening the ethical environment within the public sector itself and start to manage the existence of fraud, corruption, and reduce those. And there needs to be specific measures to encourage and protect whistleblowers. I think, Chair, what we did note is that the bill does talk about the protection of the affected persons that report whenever there's non-compliance from a job protection side. But we do know that there is instances where there's a risk to safety of your own life.
Hello. Yeah.
Yes, Chair.
You exceeded 12 minutes, and I'll give you an extra minute.
I can hear you, Chair.
Yeah. Okay. Thank you.
Thank you, Chair.
For another minute and a half, it's fine.
Okay, thank you, Chair. So, Chair, I think what you're saying is whistleblower protection becomes very important, especially the safety of the human life itself. And also there must be safeguard arrangements against the, existence of non-ethical behavior within the environment and how those can be better managed. So I'll skip, Chair, to this side as I conclude. We do have a written submission that we have made, Chair, to the committee, and we do say that here, Chair, that there needs to be the linkages within other legislation to make sure that the legislation takes into account all the available legislation and Chair, the improvements in technology are very important, especially from a conflicts of interest perspective. Like I said, you need to have those linkages and be able to identify those suppliers that do not necessarily need to be suppliers within the public sector because of their inappropriate acts, and also ensuring that the department process is fair. To the suppliers. I think it's also very important because then it avoids the long.
Now look, we get it. It's there. We're going to read it. There are going to be responses to it, both from our side and Treasury. Thank you very much. Can we move on to Public Affairs Institute, please? To be fair.
Thank you, Chair. My name is Mbongiseni Buthelezi. I'm the Director of the Public Affairs Research Institute and an Associate Professor in Anthropology at the University of Johannesburg. I'm going to just speak very briefly and then hand off to my colleague who's going to make the substantive presentation on our behalf. First, I'd like to thank you, Chair, and thank the honorable members for the invitation for us to give this oral presentation. My colleague, Ryan Brunette, who is one of the experts on public procurement, is going to give our presentation. Like Mr. Benga before me, I'd also like to say we welcome the development of this bill. It's been long in coming, and the Public Affairs Research Institute has been in existence for nearly 15 years. And for 12 of those 15 years, we've done extensive research on the public procurement system as part of the broader work that we do in researching the systemic drivers of state performance in South Africa, putting that in international comparative context. We make evidence-based recommendations, and we also partner with various state institutions to implement some of those evidence-based recommendations and solutions to governance problems in the state. Some of those partners that we've worked with include the Presidency, the Public Service Commission, as well as the South African Local Government Association. We've been involved in supporting the NETLEC process on the research side, along with other partners who are going to make presentations later on today. And so our presentation today is based very much on having accompanied the development of this bill over time. As much as we welcome the bill, we also still have some concerns about elements of it. And so our presentation is going to focus very specifically on certain areas of the bill that we have concerns about. And with that introduction, I'd like to pause here and hand off to my colleague, Ryan Brunette. Thank you very much.
Thank you, Bongiseni. Thank you, Chair. Thanks for letting us speak here today. So I'm just going to jump right into it. We've been with this bill for some time. We support expanding preferential procurement, but we want to argue that to avoid legal challenge and operational disruption and various issues, preferential procurement must be firmly grounded on Section 217 of the Constitution. It must be closely aligned with the rest of the bill, and it has to be kind of rigorously consulted and deliberated. From this perspective, we're very concerned that the new Chapter 4, which deals with preferential procurement, fails these tests, and that the project of social transformation and economic development through procurement will, in result, be set back. In the following presentation, I'm going to cover constitutionality, alignment with the broader bill, and then third, the need for kind of more rigorous consultation around the substance of Chapter 4. So a bit of background. Section 217(1) of the Constitution provides that procurement must proceed in accordance with a system which is fair, equitable, transparent, competitive, and cost-effective. Section 217(12) reinforces that these principles do not prevent the use of procurement to achieve socioeconomic objectives, but our courts have held that this does not mean that the Section 217(1) principles no longer apply. Section 217(3) requires national legislation to set a framework within which Section 217(2) must be implemented. And the purpose of that framework is to ensure effectively that the procurement system continues to kind of strike a balance between the Section 217(1) principles. We don't think Chapter 4 does this. The existing preferential procurement point system is not perfect. And there are ways to kind of greatly improve it and to expand preferential procurement within the ambit of the Constitution. Nevertheless, what the existing preferential procurement system does is at least attempt to strike a balance between the constitutional principles by establishing the norm that procurement will proceed through open competition scored on price and preference, which is to say that the preferential point system is broadly fair because it opens participation to all comers according to established and widely accepted rules of the game. Equitable, because it recognizes historical disadvantages and allocates preferences to address this. Transparent, because adjudication is simple, clear, objective, and measurable. Competitive, because open competition is the default and any restrictions on competition must be justified. Cost-effective, because it focuses decision-making on price and leverages competition between sorry, I'm just losing my leverages competition between suppliers to reduce costs for the fiscus. The new Chapter 4 departs from those principles quite significantly. It restricts participation in procurement from the outset by establishing set-asides as it would appear to be the norm, and procuring institutions must now justify departures from those. It does not establish a clear set of rules for how participation should proceed. We've looked at this chapter for a long time, as have many other people, and there's broad confusion and concerns regarding how exactly it's supposed to operate. It appears to suggest that procurement systems in very similar circumstances can pursue radically different procurement policies, which may or may not be equitable in those circumstances. It does not establish any objective and measurable grounds for adjudication. It doesn't require restrictions on competition to be justified at the outset. It never mentions price, which is highly unusual internationally. These are all significant departures from the principles of fairness, equitability, transparency, competition, and cost effectiveness. And the framework introduced in Chapter 4 establishes little by way of guardrails for constraining them or mechanisms for bringing those principles back into balance. This bill will very likely face constitutional challenge, and this is going to put us back to where we are in the wake of the Agribusiness decision. There's some broader issues with Chapter 4 that I'm going to deal with. The first is kind of like the issue of alignment between Chapter 4 and the rest of the bill. We think there are serious issues with alignment. A central purpose of this legislation, as expressed in the bill's preamble, is to construct a single statutory framework for public procurement. The bill now establishes, if one reads it closely, two frameworks, one in Chapter 4 and another in Chapter 5. These frameworks deal with overlapping subject matters, but the first is now largely built up in statute, and the second is largely deferred to regulations. There was in the past a clear rationale for why the second deferred to regulations, which was to facilitate flexibility in evolving the procurement regime, especially with regard to procurement procedures and structures. But Chapter 4 now entrenches a series of procedural steps in the statute, and so at various points it interferes with Chapter 5's objective of creating a flexible, strategic, and innovative procurement regime. There's ways to kind of include stuff in a framework in statute that creates the kind of flexibilities that you need to roll out a system and regulations. Chapter 4 doesn't do that. It doesn't establish a high-level principled framework. It points to specific procedures that will make it very difficult to kind of, in law, elaborate forms of strategic procurement. Another broader, maybe underlying issue has to do with consultation. These issues have emerged in Chapter 4 because Chapter 4 is essentially unconsulted. NEDLAC played a crucial role in addressing issues in prior iterations of the bill. The NEDLAC Act asserts at Section 5.1d that NEDLAC shall consider all significant changes to social and economic policy before it is implemented or introduced in Parliament. The changes that have been made to Chapter 4 within the National Assembly are wide-ranging. They affect 1 trillion rand of state expenditure annually. The courts have repeatedly asserted that public procurement is highly significant for social and economic development. What we have here is a Chapter 4 that effectively hasn't gone through the legal processes. These wide-ranging changes in Chapter 4 were introduced late in the legislative process without input from social partners. We therefore propose that the bill get referred back to NEDLAC for proper consultation. We argue that this will likely end up saving time by avoiding long and arduous litigation and various other problems that will result from this bill. I'm going to finish up by just noting a series of continuing kind of issues around integrity and transparency. We suggest several further changes to the bill in our submission. In this area, we propose specific legislative language that may be useful. First, the powers of the PPO and provincial treasuries to review the procurement policies of procuring institutions have been taken out of the bill in the National Assembly. They were there, now they are gone. We see powers of review of procurement policies as the basic function of a strong central regulator, and we believe that those powers should be re-included. We think that the capacity needed to perform those powers isn't beyond the scope of the OCP or of the Public Procurement Office if exercised judiciously. Second, we've noticed some tension between Section 30, which deals with ICT-based procurement, and Section 25 and Section 33, which provide for procurement methods and transparency, respectively. Essentially, the way we read it, Section 30 creates a kind of parallel process for expanding procurement methods and transparency. And we argue in our submission that Section 30 should rather, or should instead be more closely aligned with and refer to Section 25 and Section 33 to avoid kind of inconsistencies creeping in between these various systems. Third, Section 33 still needs to be aligned with amendments to the Companies Act. It was dealt with in NEDLAC before amendments to the Company Act were made. Those amendments deal with kind of beneficial ownership specifically in both section 56.7AA and subsection 12, section 56.7 or section 56.12, sorry. So that's the minor rewrite. Basically what happened in National Assembly is
You're
a
at
swap
12 minutes almost, we're at 11:40. You've got 20 seconds left, please.
Got it. So yeah, that just needs to be clarified. Fourth, we are worried about the definition of confidentiality in section 1. In South Africa's legislative landscape, the legitimate scope of confidentiality is established in the Promotion of Access to Information Act. The Protection of Personal Information Act largely addresses how institutions handle personal information by including within the definition of confidentiality personal information protected in terms of the Protection of Personal Information Act. In the bill's definition, that reads a little bit too broadly. It could potentially make all personal information confidential. We think it should rather be hinged on the Promotion of Access to Information
Okay,
Act.
thank you. Look, you'll have to draw to a close, I'm afraid. I hate doing this.
I understand,
if you have
Chair.
another chance, you will come back on Friday the 8th, and you will have an opportunity to respond to Treasury, okay? No committee does it apart from ours that I know of. And remember, this bill has already been taken through the NA, and it's been in the making for over 12 years, if I'm correct. I don't know, I've forgotten. But I think in 2014, Lady Mashlanga will tell you, they told us they're coming with this bill. And they've had endless exchanges, from what I know, through workshops. They've gazetted it, so it's not as if this is the first process. I'm just very struck. Okay, let me not just say right now anything. Let me not preempt what the members will say. Let's move on to Busa. Thank you very much, sir. I'm very sorry that we had to stop like this, but I have no choice. As I said, I don't... Busa, you know you next, right? So let's go for it. Is Busa here in Kulileko?
Yes, Chair. I saw Mr. Tyson Sibanda. He's here.
Yes, Chair, and Chris Campbell is doing the presentation. I'm just trying to share.
Yeah, sure.
I'm just trying to share. There seems to be some difficulty here. There we go.
Thank you.
All right, if you can just put it into the presentation mode. Thank you. Good morning, Chair, and thanks for the opportunity. I'm mindful of the short time. I've set my...
not too short. We're going to read
stopwatch.
this. We're also going to meet next Friday. It's reasonable, really.
Thank you. So I've set my stopwatch. I will try to be as succinct as possible.
So yeah, good.
Thank you. So that's the format in which I'm going to present today the Busa position, and I want to start with the opening remarks, and from the onset indicate that, of course, Busa as the Apex business organization are aligned with the motives for such all-encompassing legislation, and of course with the attempts for us to try to meet the prescripts of Section 217 of our Constitution in all of its subsections. But, you know, we would also hasten to say that in the past, and lessons learned, which we want to improve on, is least cost decisions in contradiction with what's cost effective, excessive pricing, overly competitive competition, and that kind of behavior, whether that's destructive or constructive. And, you know, there are several other key questions around how do we differentiate between what should be treated more strategically and what should be treated as commodity procurement processes. On the questions of fairness, and I just want to talk about the document, the bill itself, reflects insufficient evidence of how we've taken into account the learnings and the advice from the Zondo Commission. And of course, there's still a gap where we could deliberately insert incentivized whistleblowing, because we need quick reaction, real time, to be dependent on another process elsewhere. We've seen how the perpetrators tend to get away, get out of the country. To use the expression, they get out of Dodge very quickly. So, and then the other one is the standalone triple PFA, which we've always had problems with that. And the fact of the matter is, right now, in Chapter 4, which seems to be a really focal point of most of the discussions. There is still deficiencies in whether it constitutes a framework, but there are other concerns we'd like to ventilate. So if we can move to the next slide. And I'm cutting to the chase, Chair. We're advocating for this public procurement bill to be referred back to the NEDLAC process to strengthen it, so that when we get it signed into law, we can move forward. There are too many pitfalls that one can see. We will immediately find ourselves stymied and will stall. Also, if it does get signed off and we embark on regulation setting, then we are once more stuck with the situation of trying to convert a donkey into a prize-winning racehorse. No offense to donkeys, of course. Why am I saying, and why are we advocating for that? In the NEDLAC report, it's very clear there's been many areas of disagreement between the social partners. Most often, business and labor were aligned and in agreement, and most often, government led by the National Treasury not. We would also contend that it does not, whereas it's meant to consolidate the fragmented legislation, there's still many gaps which haven't been addressed, which are sitting in the PFMA, MFMA, which not of necessity belong in regulation. They could be, yeah, if you are trying to do something all-encompassing. And this is just an effort on our part, along with others, and this is not a singular view. There are experts in procurement law, global procurement practice, construction industry, and even public sector entities, I would hasten to add, whose inputs have been dismissed in this process. Despite, and I heard your comment about a 10-year process, but I will share more in the next slide. Please, next one. So, I'm not going to read verbatim, but I want to just maybe under the third bullet, share with you the fact that a NEDLAC process for this bill was 6 months, a generous 6-month period for social partners to consider it. Even at that time, it did not appear that there was much research that had gone into it on how are we actually going to get this right as groundbreaking procurement. And the contrary, though, was that the last consultation had ended in 2020. So for 2 years, National Treasury, through the Office of the Chief Procurement Officer, had this in their possession, and surely we could have done better. And so we did feel but shortchanged in the NEDLAC process. Then what's becoming clear is that we seem to be rushing this bill to address one factor, and importantly so, we would not deny, and that is, how do we give credence to preferential procurement as in section 2173, so that we meet the prescripts of 2172. But, you know, I think there are other pitfalls which we need to take stock of, because they too will make us not maximize and optimize the public spend. And another risk that we have is that there appears to be, again, questions around consultation, not only NEDLAC and the newer version of the public procurement of the preferential chapter 4, preferential procurement section, but also in the consultation where as much as 64% of input invited to comment to the National Assembly apparently and seemingly had not been incorporated or considered. And we are aware of existing legislation which on that same grounds has caused, even after the president has signed the bill off, caused the Constitution Court to nullify it, and everybody goes back to the drawing board. So if you can go to the next slide, please. I've ventilated a bit more on chapter 4. I'm not going to dwell on it because I think there's a real risk that we may find this session only about chapter 4, and there's enough issues around what we need to reconsider. But what is key there is the overlap in chapter 4 and the marginalization of the BBBE Act, which if we allow ministers the opportunity to willfully and willy-nilly decide when it should be included and when not, then that begs the question on whether we're serious about that. And we also are threatening the livelihoods of those beneficiaries of such broad basing. We've seen evidence of entities putting out strange requirements around ownership. And furthermore, if we look at what is the real question and why in the public domain, and especially public entities, are they questioning the BBBE in its current form and its successes? Simply because we are not taking stock of what is the ills that are causing a bad impression to what is a well-intended and successful in the construction industry. For example, there is evidence from the scorecards and the reports that have been tabled to government of its successes in all its dimensions, the skills development, the enterprise and supplier development, which I do not believe we would want to lose or reverse. Next slide, please. I did mention the environmental legislation, the Zondo Commission and the lessons learned that should have been here. Also, earlier on, why we believe incentivized whistleblowing should have been deliberately put in this bill. There's precedent for that. It exists in the environmental legislation. And you know, once again, if we look at the time delays, just from the findings in the Zondo Commission and state capture era, how many are still not where they should rightfully be after infringing and breaking the laws of this country, it makes it even more imperative that we have a more online, on-tap, real-time opportunity and system for doing so. And then I also want to say that the in the session the other day, listening in and you know, wonderful word, expatiated version of the chapter 4, we've done the research. We've also compared with others who've looked at it similarly, and it's clear that either we are at pains of playing with words and defining to what extent an expatiation constitutes something new, or whether it's slightly enriching. We would contend that it's too new not to have been reconsidered, at least at the NEDLAC review process.
As you know, you're at almost 10.5 minutes. Thanks.
Yes, I'm wrapping up now. Thank you very much. I do have, so if I can go to the next slide. A very important point I'd like to ventilate here is that this bill, it says patently procurement. We spend 4.5, our GDP is 4.5 trillion. Our infrastructure asset spend over the last, say, a 20-year average has been 750 billion. And yet we relegate the mention of infrastructure, just as one example, to 2 lines in this bill, which that cannot be. We don't seem to be serious about how do we maximize the public spend in a country that's rapidly running short of money. And I'm not going to dwell on the last point. If you can go to the next slide. The urgency, of course, we understand, but sometimes urgency can make you just go all the way, be forced to go all the way back. And we would like to say that it would be counterproductive to hope that by accelerating this the floor piece of legislation, and even, no disrespect, Chair, the time that it's taken is we should take the opportunity to get it right so we can move forward. Next slide. And, you know, I think just from business as social partners, we are hopeful that you know, all of the inputs will be deemed to be constructive, taken stock of. Let us get better bang for our buck, because at the end of the day, it's exactly what we need as a country and as a society. Thank you, Chair.
Thank you. African Procurement Law Unit. Thank you.
Thank you very much, Chair. I will just share my slides as well. Thank you, Chair. We thank you for the opportunity to make submissions on the Public Procurement Bill. I'm Gio Kino. I'm appearing for the African Procurement Law Unit, APLU. Very briefly, APLU is a multi-institutional academic unit focusing on the study of public procurement law in an African context. Our administration is currently based at Stellenbosch University, where I and our Deputy Director, Professor Williams, are based, and at UNISA, where our other Deputy Director, Dr. Alison Anthony, is based. We have affiliated researchers at 10 different universities across Africa and beyond. In my submission today, Chair, I want to highlight 3 themes from our written submissions, which we trust the committee and the council will find of assistance in processing this bill. As a point of departure, we welcome the tabling of the Public Procurement Bill. We think that law reform in this area is long overdue and is of utmost importance in pursuit of our National Development Plan, given that public procurement is at the heart of the engine room of government. The 3 themes I want to focus on are 1, legal consolidation in public procurement, 2, constitutional questions, and 3, resources. Firstly, then, consolidation of the law. We welcome the bill as a long overdue step towards consolidating our law of public procurement. There is no secret that one of the biggest stumbling blocks in public procurement has been the extreme fragmentation of the law governing procurement. The law is simply spread out over too many different legal instruments, which undermines efficiency because it is too difficult for procurers and suppliers to have a firm grip on the law. And this also enables corruption to thrive in the complex web of rules and technicalities. The bill, while positive, risks future fragmentation through excessive reliance on regulations. We propose limiting this by 1, setting clear principles in the bill. Key elements like procurement methods should be defined within the bill itself and not left to regulations. 2, precise delegation. Any delegated powers for regulations should be accompanied by clear parameters and guidance. And 3, focused subordinate instruments. Regulations, instructions, and notices should only handle specific details, not core principles. The current approach, leaving vast areas to regulations and also instructions and notices, raises concerns about transparency and accountability. On preferential procurement, too many key concepts are left open-ended for the minister to determine, such as thresholds and conditions, prescribed criteria, complementary goals, preferences as prescribed conditions for measures to advance sustainable development. The new powers granted to provincial treasuries to issue binding instructions to local government poses another threat to new forms of fragmentation. Not only will this subject municipalities to multiple sources of instructions, national and provincial, but it also opens the door to different approaches to procurement in different provinces based on different provincial instructions. While the bill provides for all provincial instructions to be aligned with national instructions, this is no guarantee that differentiated provincial instructions, albeit all compliant with national rules, may not emerge. Such renewed fragmentation will continue much of the current problems and undermine procurement efficiency for both procurement officials and suppliers to the state. Secondly, moving on to constitutional questions. Firstly, the need to anchor the bill and hence the future procurement law squarely in Section 217 of the Constitution. The bill fails to address, in our view, how to implement the 5 vital public procurement principles enshrined in Section 217(1) of the Constitution. This silence leaves officials vulnerable to legal challenges and hinders the practical application of maximum value for money championed by the Zondo Commission and the President. Specifically, the bill offers no guidance on navigating trade-offs between principles like fairness and cost-effectiveness, or equity and competitiveness, etc. This lack of clarity weakens the legal ground for designing policies, methods, and criteria, further hindering efficient procurement. Experts, including the Zondo Commission, have highlighted the lack of clear implementation as a major stumbling block in the current system. Therefore, the bill should provide a framework for balancing these principles throughout the procurement process. This includes defining how value is determined and the parameters for considering factors like price. Without such guidance, Chair, achieving optimal value for money and ensuring a functional procurement system remain major concerns. Secondly, on a constitutional basis, and this is probably the most significant issue for this committee and for the council to deliberate on, the bill's centralizing tendencies regarding procurement raises significant concerns about its compatibility with the Constitution's principle of cooperative government. This centralization manifests in several ways. The bill heavily relies on regulations, instructions, and notices, leaving limited control for individual organs of state over their procurement policies. This significantly reduces the autonomy of local governments, especially, who currently have legal authority to set their own policies. Power over key aspects like procurement methods and preferential practices shift heavily towards the national level, potentially violating the constitutional mandates of local and provincial governments in sections 104, 124, 151, 152, and 153 of the Constitution. The bill lacks provisions for consultation with local government structures like COCTA and SALGA, for example, particularly regarding the issuance of subordinate instruments. This further undermines their role in shaping local government practices. And finally, the proposed single national tribunal for procurement disputes raises concerns about potential bottlenecks and delays. A decentralized structure with provincial or regional tribunals could better align with cooperative governance principles in our Constitution. These issues pose practical and constitutional challenges. The diverse nature of South Africa's public procurement landscape necessitates a more enhanced approach that balances national oversight with local autonomy. Centralizing power at the national level disregards local knowledge, needs, and geographical disparities, potentially hindering optimal procurement outcomes. Furthermore, the lack of consultation with local government contradicts the spirit of cooperative governance and could lead to legal challenges. A more inclusive approach, respecting the distinct mandates of each sphere, is crucial for an effective and constitutional procurement system. Therefore, we recommend a thorough review of the bill's powers allocation between the spheres of government, a more balanced approach, granting local and provincial governments greater autonomy while ensuring national oversight and compliance would better align with the Constitution and enhance the effectiveness of the public procurement system. My final point, Chair, relates to resources. The bill introduces significant new functions and shifts in existing ones, demanding substantial resources for successful implementation. However, the bill, in our view, fails to adequately address capacity needs or professionalization, raising concerns about its feasibility in practice. The bill imposes several additional tasks on provincial governments, especially treasuries and local governments. These include enforcement functions, investigations, internal review structures, and market research obligations. However, it offers no statutory basis that guarantees the enhancement of their capacity to fulfill these roles. The Socioeconomic Impact Assessment Report acknowledges implementation costs for provinces and municipalities, citing needs for additional staff, technology, and training. However, the report and the accompanying memorandum tabled with the bill contradicts this, claiming no substantial financial burden on the state. This discrepancy raises serious concern about the accuracy of costing and the commitment to resource allocation. We propose adding a provision to the bill explicitly mandating increased capacity and professionalization. This provision should oblige relevant departments, like national and provincial treasuries, to allocate additional resources to procurement functions, commensurate with the expanded mandate. Additionally, incorporating requirements for mandatory competency levels and training obligations would foster professionalism and efficiency within the system. Ignoring these resource concerns would risk creating an unenforceable and underperforming procurement system. By ensuring adequate resources and professionalization, we can pave the way for the bill's successful implementation and achievement of its stated goals. And with that, I thank you for the opportunity, Chair, and we'll be happy to answer any questions. Thank you.
You only used up 10 minutes, actually. And then you're going to have more time next week, in fairness. Now, I'm being serious. You'll remind me, sir.
Thank
Thank you. Very clear, very effective. I'm not saying whether I agree or not. Let's see what members have to say. Look, it's early days yet. We're not rushing into this bill. Can you calm down, everybody? We're not going to rush into this bill. It's our own integrity at issue. It's a 76 bill, not a 75 bill. And you know, if we are, you must remember that you can spend 6 months on a bill, but if you add the number of hours, it may be only what, 25 hours. You can spend 6 weeks on a bill, and you can spend 150 hours. But also, it's the quality of those hours. So nobody's going to rush this bill, okay? It's a complex bill. Already, all of you have signaled problems from different angles. So we ain't going to rush it. That's clear. That's not a discussion the ANC study group has to have. As a representative of parliament, as a chair, oh yes, I have strong views as an ANC member, but I'm also a parliamentary chair. I have to abide by the rules and norms of parliament on public consultation and other issues. So no, we're not going to rush it. But you have to play your part and don't come to us at the last minute with submissions and so on. On the NA side, just to alert you, the committees that I've been in, we've allowed submissions till the last day. On the NCOP side, on the eve of an election, we don't have that capacity. What we will give you some space in Kululeko, maybe we should do it now and let them know after National Treasury replies to you next Friday and you reply to them, and then we start the discussion. We will give you another week to make further submissions. But you too have to operate in a fair way. You know, the difference, I'm saying all this because there are others who are going to come here and say, don't rush it. So that's why I'm intervening. Don't worry. All of you will get your 12 minutes or so, right? All I'm saying to you is, look, this is not the be-all and end-all of our exchange. You can be given another week after next Friday, or the following Friday, will be the 15th of March, to make a submission on what you think after these discussions, especially next Friday, still need. And then you must actually prioritize. You can't get everything you want. Some of what you say is in conflict with what other civil society stakeholders will say, let alone National Treasury. So we'll give you that space to come back with written submissions. And you have to operate on a, you know, like give and take spirit also. You know, you accuse us politicians of having a one-track mind. You know, we have a policy, we're going to implement it, and we're not listening. I don't buy that. That's not true of Parliament as a whole, and not true on every bill. That's my experience after 30 years almost. But let me put this to you. The problems we have, and I understand if I was in your, and I will be in your shoes very soon after May 29th, if I was in your shoes, it's still, most civil society stakeholders have a very precise set of goals and they want that. And you don't think enough about what another civil society stakeholder belonging to the same broad progressive tradition also needs that's in conflict. So it's a give and take. Ideally, you know what I would say? Having listened to you already, I'm making this clear to you, Treasury. If it was on the NA side, I would say, you know what? You go and sit with these people for 48 hours and sort these issues out. And if it comes to it, it may have to be. Because already you can see, I don't know if all of this is correct. I don't even know whether all of this was dealt with by the NA. But it's not looking good so far, Treasury. I hope you come with formidable answers and not your cliche-ridden replies. We're not going to have that, okay? But on the other hand, I'm also clear, Treasury. When people are opposed to a bill, they use all sorts of excuses. It's constitutionally unsound, the process is wrong, etc. Most of those times, very little of what they say gets reflected in a court outcome. At other times, they do. So basically, Treasury, can you up your game in your replies next week? Thank you. All right, next, please. Is joint strategic resources not here? There they are. I can see them on the screen. So what's the problem? Where's the Professor Claren? Is he not here?
He is here, Chair. He's the one sharing the presentation.
So why is he so? Can you please go ahead, sir?
Yeah, my apologies.
No problem. Go right ahead, please.
Yeah, sorry about that. I was sharing, but I was muted. Yeah. So I'll continue from here. Thank you very much. Yeah, and just so we'll aim to put this presentation into that theme of this is a very complex bill, and yeah, in a 10 or 12-minute presentation, it's not possible to cover everything, but we'll certainly try to.
Yeah, but you're an academic, right? And when you travel to the other end of the world, how many minutes do they give you? I've traveled overseas as a former academic. They give me 10 minutes after 6 months of research and putting together. So please.
It's pretty much similar, I agree. I've been an
Yeah. The university paid thousands of rands for me to go and speak for 10 minutes. And same applies to you and all of you professors here. So let's move, please.
Okay, we're moving. So who and what is the JSR? I'll spend a little bit of time on this. I think the business BUSA presentation has explained and gone into a little bit of depth around the NEDLAC process. And that's effectively where the quote JSR emerged from. I'm Jonathan Claren. I'm a professor at Wits. And together with about 5, 6, 7, 8 others who are persons, professors, but also some researchers in civil society who have expertise in public administration, in construction management, and in procurement policy. So we had been asked by the task team at NEDLAC to provide expert advice in the statute when it was being considered there. So drawing upon the BUSA presentation, I think it's probably fair to say that that suggestion was made by the business and labor constituency, the social constituencies. And then we were not parties, but we were called upon at certain points over, I think it was about a 2 or 3 month process to give advice on particular formulations in the bill, to explain some of the procurement policy or construction management or public administration issues that we had seen. And certainly our intention, I think the effect, was to play a constructive role in the progression of this complex bill for that NEDLAC period. And yeah, there's been an afterlife then of the JSR, and I guess this is part of that afterlife. The sort of collective discussion amongst those experts from different fields has proved to be useful, at least from our point of view. So this is actually, I think, the third presentation that we've made in the public consideration of the bill. The 2 earlier in front of the National Assembly, and now we are here at the NCOP. Yeah, so we stand ready to participate as certainly as called upon or desired, and comes out of this NEDLAC history. So what we're doing in this presentation, and not sure if I'll get to all of it, is to look at 3 parts. First, the idea that the bill, has already been alluded to in a number of places, raises significant constitutional issues. Second, that we feel the bill should provide for the independence and effectiveness of the regulatory functions in public procurement, and we'll explain that a bit more, and that it needs strengthened anti-corruption enforcement mechanisms. And here we're talking about alignment of investigative powers, debarment, incentivized whistleblowing, and independent contracting. So there are 3 issues in these slides about significant constitutional issues. And although, for instance, here, the cooperative governance issue that Professor Clino adverted to in the presentation just now is not listed. We've got a listing of some of the constitutional issues that are there, and I think it is fair to say that that extension of the bill and the operation of the bill within the local sphere does certainly raise potential significant constitutional issues. The point to this slide is what you can call the system issue, which is really the question of whether the bill, and we're unfortunately in the opinion of saying it does not, whether the bill gives a clear answer to where is the balance and how does the development of the procurement system between the procuring institutions and, at this point, a unit inside of National Treasury works. Who is the first mover, even in setting up some of those public procurement policies? Now here, there's actually two constitutional issues. We're not referring to the Chapter 4 version of this issue, which might be understood as a framework issue. Here, it's more the larger system issue. Secondly, there are the issues with Chapter 4 itself. I would agree that it does not make, it's probably not the most constructive to be entirely talking about Chapter 4, but it certainly does get a lot of discussion, and that's for understandable and good reasons. Yeah, so in our view, the revised bill, the Chapter 4 that's kind of newly put in, is not clear, does not send out the standards for implementation. There are a number of places where this is pretty much at the level of detail, but even at the level of interaction between particular sections, there's contradictions or overlaps that do not assist implementation, and it appears to fall short of that constitutional framework standard. That said, I think one thing, I do some work at Gauteng with green public procurement, and we'd like to, or certainly I'd like to, give a shout out to the inclusion of Section 22, which facilitates sustainable development. It's good to see that in the latest version of this bill. Last of these constitutional issues is what you can call the principles issue. The way Professor Kino was talking about it as the entrenchment and the drawing through of those 5 principles from Section 217 into the statute, that's not done in a significant or adequate way, so we would agree with that. But I think also what might be important to understand, and this is less, in some ways, less a constitutional issue, although it would impact on judgments around rule of law and effectiveness, is just as a matter of how do you give effect to the policies here. Having in this complex area, having a statute that was built around principles that said, for instance, in statute, what procurement methods would be much more effective and would have much more of true effect in terms of knitting together this very fragmented field. This is the second of our third main points here, which is about the independence. So there's been, to some extent, a bit of a silent or sleeping question around independence of the public procurement regulatory functions. And I think we would wish to make the point to the parliamentarians in the NCOP and of course the broader parliament considering this bill right now, that on the whole, adequate independence of these institutions that are doing the regulatory functions, this is as distinct from the purchasing or buying functions. At the moment, the OCPO is effectively doing both. The title is the Office of the Chief Procurement Officer, and that kind of brings together the idea of the chief buyer and the chief regulator at the same time. What we would say as a general proposition is the independence of the regulatory functions actually conduces to, helps effectiveness and efficiency. Therefore, we think that consideration should be given to splitting those functions. If that were done, then the chief buyer function should obviously, obviously, should be continued to be exercised within National Treasury. But it is possible to consider, and this has been considered at various points in that relatively complicated up and down complex 10-year history of this legislation, for an independent regulatory body, something like the Competition Commission and Tribunal structure, which would be distinct from National Treasury. So that's the second argument here. And I suspect we might be talking about that more on the 8th of March, Chair. The third argument, which I think I've got a minute or two left, so speak to this, is about, so it's a mistake to approach public procurement purely from a strengthening of anti-corruption point of view. However, that said, it's equally a mistake not to understand that this is an area where anti-corruption purposes need to be fulfilled, and in particular where greater anti-corruption enforcement and enforcement mechanisms are necessary. So one element that we're not seeing at the moment is an appreciation for and a desire to begin to align the kind of inspection powers, that would be sort of regulatory compliance, non-compliance, using that terminology, or civil investigative powers, that's the kind of special investigative unit, SIU powers. We would like to see greater attention to, or actually the review that in fact, I believe National Treasury has called for in its comments be carried out in order to align those kinds of inspection powers or investigative powers with the powers existing in, say, the SIU. For those of you who have been tracking at the SIU, it started out doing kind of small bits of fraud and corruption and various little bits, but it's really developed an expertise in complex procurement fraud over the last, say, 10 years. And that's in some of the documents that they've got. Therefore, the alignment is an important thing. There should be discussion.
Almost 12 minutes.
12 minutes, okay. So,
almost there.
Thank you. So I'll just say debarment and incentivize whistleblowing are also places that we feel should be in the bill. So I'll end there, but thank you very much for the opportunity.
Thank you very much. Over to NRF, please. Are they here in Kululeko?
Yes, Chair. Ms. Lindiwe Ngwe is here.
Okay, please go for it. Thank you.
Good morning, Chair. I hope I'm audible enough.
Oh, you're very audible. Thank you.
Thank you. My name is Lindiwe Ngwe, and I'll be taking you through on a high level the NRF presentation. We are a PFMA Schedule 3A public entity. However, Chair, you'll see that our mandate is not only limited to the national department, but it extends to all three spheres of government. And we pride ourselves as the NRF that we currently host the largest science project in the world and the largest science infrastructure on Africa, which is the SKA project. One of the key things that drove us to submit our comments to this committee is the fact that as part of the NRF mandate, we seek to promote the development and maintenance of the national science system and support government priorities. And that's why it was key for us to provide inputs into the bill. If we have to look at the national science system, it's a system of interconnected institutions that create, store, and transfer the knowledge, skills, and artifacts that define the new STI. So we are across the board, like I said, Chair. We have visibility in the provincial and municipal entities. We also have a visibility in the national departments that I've listed now on the slide. I'm not going to mention them because I believe that you can see them. So in terms of appreciation, Chair, we really appreciate the opportunity as the NRF to be able to provide comments and present to the NCOP. We also appreciate the early consultation, which was facilitated by National Treasury. Though, Chair, a little bit disappointed because we provided comprehensive inputs, and I can say only 3 or 4% of our inputs were taken into account. And I want to reiterate what you said to National Treasury, Chair, that please, they need to go back and strongly consider including entities' inputs into this bill. And we also welcome the fact that the bill, it's talking to innovation, which is our passion as National Research Foundation. So one of the key things that we have identified on a high level with regard to this bill is the issue of innovation. We want to request that National Treasury should consider elevating innovation in the bill, not as a subcategory as currently stated, but we want to be a same level as subsection, so that it's very clear, because we believe that innovation plays a critical role, especially in elevating some of the challenges that we are facing as a country. And we also of the view that the current legislation, then the current environment, it's not conducive enough for one to be able to enter into the procurement system, the innovation-enabled environment. And when we look at section 16, the power is granted to procuring institutions to develop their own procurement system. But section 17, the power is granted to the minister to prescribe the procurement system. So we just want to recommend that the minister must prescribe appropriate and differentiated framework at the minimum for innovation-centric procuring institution, ideally for all of us who are in the procurement space, because of, if you look at the bill currently, it's mostly talking to your general procurement. I always say like procurement of tea and coffee. And that's why we are also suggesting that the bill should include specific procurement methods that will address innovation, because the current procurement methods that we have, they are not enough to address the procurement of innovation. And we are making ourselves, Chair, available as the NRF to assist National Treasury in developing these innovation methods. So we are saying to them that if they need assistance, we are one government, we are available. They can come to us, and then we can assist. So we also recommend that we need to have a center for procurement of innovation so that we can provide training and support innovation procurement method, tools, and guidelines. And I must mention, Chair, that to date, as the NRF, we are currently at infancy stage in terms of developing this Center for Procurement of Innovation. So Treasury is more than welcome to partner with us so that we develop this Center for Procurement of Innovation, not only for us, but also, Chair, for our future generation and for our youth who are currently unemployed. So in terms of the categories, we recommend that over and above what is currently there, these categories that I've displayed here, they should also be included: commercialization, sole suppliers, the process of disposal within the research project, because one of the challenges that we have is that there's no clear guideline in terms of how do we go about disposing these research-related projects. So like I said, when you do innovation, it's quite different. You can't use the current procurement methods. So we are suggesting that as the NRF, we need to have the methods that will support innovation of procurement, and that will also assist in innovation-specific procurement methods and methods which are also friendly. And the bill must clearly define the system, the type of methods and procedures available. That information we do have, we are willing to share with the National Treasury. So the other challenge that we identified in the bill is the tramping of innovation out. The NRF and other research and development institutions, obviously, like I said, as part of my opening remarks, are established by our own act. So currently, the way the bill is structured, it looks as if this is going to be a primary act over and above the other acts that we have. So we are saying this act must be applied by way of appropriate differentiation between different contexts that merit differentiated procurement regulation. And this was also shared or provided by Prof. Gio. And then a lot has been said, Chair, about Chapter 4, and as the NRF, we do agree with the previous speakers I am not going to say more about it because of a lot has been said. There is a challenge with Chapter 4. We recommend that a National Treasury must strongly go back to the drawing board and look at Chapter 4. We cannot, for example, have a pre-qualification set aside in one bid document. And for the purpose of the provincial and local government, we are also of the strong view that Section 18.3 of the bill, it should be removed or deleted and be managed via regulation so that it gives the provinces and local government to make their own powers. And the other challenge that we identified in the bill is the issue of the cost implication. Section 35 of the PFMA states that the national legislation that assigns an additional function or power or impose any other obligation on a provincial government must do so in a memorandum that must be introduced in Parliament with that legislation, give a projection of the financial implication of that function, power obligation to the province. So the challenge here is that the current memorandum, Section 5 to be specific, it says no substantial financial implications for the states I envisage. We don't believe that is the case. And also, the Section 279, this was provided by Prof. Rio, of the Rules of National Assembly requires that all bills introduced by a cabinet member must be accompanied by a supporting memorandum. So in light of that, we have identified as the NRF that the following are key high-level costs that are there in the bill, which National Treasury said is not there. The costs associated with setting up a new or revised implementation structures of the proposed procurement regime. For example, asset management, there are a lot of functions that has been added to procurement, and in the past, some of the entities did not have those functions in their procurement units. The compliance costs, these are costs associated with the operation of the procurement regime. Once it's been set up in terms of the procurement bill, we're gonna have to have trainings, we're going to have to do change management and all that. So we're going to have to ensure that everyone internally, our internal stakeholders, our external stakeholders, they familiarize themselves with the contents of the bill, and that it requires cost at itself because it's a compliance cost that we as the NRF are going to incur, but not only us, I think all organs of states. And then the procurement costs. The bill increases the cost of goods and services procured under this new procurement regime, like I've explained previously. And then the knock-off cost is the last one, cost of changes that will have to be made in non-procurement areas as a result of the implementation and operation of the new procurement regime. And the recommendation, Chair, is that all this cost implication, they must be quantified in order to determine what the financial implications for both a national government, state-owned entities, provinces, and local government are for enacting the bill. Without such quantification, we are of the strong view that the bill cannot legitimately pass. That being said, Chair, just want to take this opportunity to really thank you and your committee for giving us this opportunity to present, and we have submitted our comments, Chair. They are very comprehensive. The committee has a lot of reading to do, including Treasury. It's 141 pages. Thank you, Chair, for the opportunity.
Thank you. We have to be realistic. If you went to Germany or to the US or the UK, I don't think an average MP will read one submission of 140 pages. They have staff of, well, the US Congress people have 14. That was about 15 years ago when we visited them, members of staff. So that's unrealistic, but we will look at the summaries. Can you summarize it in 10 pages, executive summary? I want to be honest with you, I'm not going to read 140 pages. There's no rule in Parliament that requires me to read 140 pages, but Treasury has to do it, and they've got plenty of time. There's no excuse, Treasury. But I also want to clarify, Madam, what I said. I was very clear. I did not say that they must include everything you say or anybody says. I simply said, if I were in the NA and Dikeledi Mashlangu, the the chairperson of appropriations will tell you that, the chartered accountants, your predecessors will tell you, we sent packing. We said, hey, don't come back to us, Treasury. Go and sort these issues out with the stakeholders in Tshwane and come back to us, and you tell us what the outcome is of that process, and you stakeholders tell us whether it's a reasonable reflection of that. We didn't tell anybody to go and meet all the needs of all the stakeholders, which are inconsistent with each other, as I said. But this process has been gone through in the NA. And though it's a 76 bill, we also have to take that into account. But what I'm saying is they must meet with you, and I may still put it to the meeting, and we can discuss this after the 8th. Not to agree to everything all of you say, which means the bill won't come back for another 10 years, but to actually hear you out and give you arguments where they've turned you down about why they haven't agreed. And Treasury, are you listening? You might have to do that, because otherwise we'll sit here through the day. We might call you in and say, can you go through each of these things and tell us? You know, you have to do it in any case in your table, and so will Esther and them. So that's clear. I don't think you need to focus, any of you in future, on capacity and money and resources. We have 1,000 times told the departments, you know what? Where's the capacity? Give us your implementation program. And frankly, even the peasants in Mongolia know the state is finding it increasingly difficult to be effective. I don't buy the thing it's a failed state, but it's reasonable to say it's beginning to fail. So more than ever, we would like to know from Treasury all these big things you want to do. Have you got the capacity? Have you got the resources? Can local government do this? Can the provinces do it? So that theme, can we just park it aside? In any case, we would have raised that. Not the DA, the ANC would have raised it. I would have raised it as a chair. So can you come back strongly on that and on your consultation process until now? Usually what happens is civil society will say, we weren't consulted. We're consulted on a scale of 10, let's say 2. Treasury will say 8, and then we'll file it somewhere in between. Okay, having said that, I now throw it open for discussion. Let's see how many hands up, and then we'll split the time. So we've got up till it's, yeah, okay. We have the discussion from 10:17 to 11. We're well behind time because of what happened initially and so on, but we will spill over 1 o'clock if we have to slightly. So fine, let's go for it. Whose hands are up? I see Dennis, predictably. Who else? Dennis, you can have...
Mr. Ryder for now, Chair.
Oh, you can have half an hour then, Dennis.
I'll take it. Thanks, Chair.
Okay, until a hand comes up, I'll let you speak. You can take up to 10 minutes, Dennis.
Yeah, Chair, thank you very much indeed. Chair, I want to make a point right at the outset, and it's a comment on what you've been saying, if I may, and you've repeated it, I think, 3 or 4 times, that this has been through the National Assembly already, and there was opportunity to comment and etc. I want to make the point very clear that what we're dealing with here is a B-bill. The National Assembly passed a version of the bill on the 6th of December. On the 7th of December, an A bill was issued, and on the 8th of December, a B bill was issued, which is what we're dealing with here. Chair, there are fairly material changes, and it's been alluded to by a couple of the presenters, but there are fairly material changes that have been that have taken place between the bill passed by National Treasury, by the National Assembly, I beg your pardon, and the bill that's before us now. So consultation on this version of the bill needs to be quite comprehensive, and there needs to be a lot of discussion. We can't assume that the National Assembly has scratched through the material content of this bill, because there are material differences, Chair. And in fact, the process is quite an unusual one and a strange one. I mean, I'm aware that B-bills often creep into the system from here and there, but the material changes that we're seeing here, and I haven't evaluated them properly, and I don't think Treasury was entirely open and forthcoming when they presented the bill to us in the first meeting about the differences between what the National Assembly passed and what lies before us now. So much further analysis is needed. Certainly, I'm going to be doing it. I'm going to be comparing the differences. because yes, Chair, we don't have 40 staff members. We have myself and my colleague Billy, and that's who does the work. So we've got lots of reading ahead of us, both of the bill and of the submissions. So that's the first point, and it's quite an important point, Chair, that I wanted to make. And I mean, there's a question here. Should the bill not have gone back to the National Assembly because of the material changes that were made in it before it came through to us? It's going to have to go back to them now anyway at the end of the process, but it's just a little weird that there's a materially different bill from what they passed that's sitting in front of us now as we take it to the provinces.
Dennis, can we just stop there?
Yeah.
For one
Yes, of
if
course.
what you're saying is correct, I don't follow. Can Frank help us? Is Frank here? I don't understand what's going on here. Frank, is Frank here? No.
Here, Chairperson.
Frank, as far as I know, no bill can come to the NCOP unless it's approved by the National Assembly, the House, the plenary. So the bill that comes here is a bill that's adopted by the National Assembly first. Is that clear?
Of course, yes.
Right. Secondly, Parliament, meaning well, in this case, the one house, they have the right to change a bill substantially. I mean, do you remember we changed that municipal systems bill or structures bill so much so that it became our bill? That was 1998. There were so many changes, Dennis, you'll know, you're a local government councillor, that the Parliament said there are so many changes to the municipal structures bill that, you know what, the changes are longer. The same happened with Johnny DeLongo chairing the Justice Committee on the, what was it, the TRC bill. So, Dennis, I don't follow what you're saying. The bill that is here was definitely adopted by the NA, and ultimately it's not addressed to you, Dennis. You're being very helpful. I'm not disagreeing with you. In fact, if what you're saying is correct, I mean, I don't know what's going on. Just clarify, Frank. Okay, what I'm saying simply is stakeholders need to realize that ultimately, you know what? You can say what you want in any democracy, even in Sweden in the 60s, when it was open social democracy, like perhaps few other democracies were. You make your case, you lobby MPs individually and collectively, and you argue, you protest, and you march. And at the end of the day, ultimately, it's Parliament that decides. It has an obligation to listen to you. In our case, it's constitutionally enshrined, and in policy terms by the ANC, at least in policy terms, we have no choice. We're supposedly people's democracy. But ultimately, Parliament makes the decision, and you have an election looming in a few weeks, and you can make decisions around that, about what you think Parliament has done in respect of the issues you've raised. So, can you clarify, Frank, what is Dennis saying that's different from any other bill that comes to the NCOP?
Chairperson, firstly, my view on this specific bill and Chapter 4 as well. Chapter 4 was changed, redrafted substantially, as Mr. Ryder, as the Honourable Ryder has indicated, by National Treasury, if I'm not mistaken, and National Treasury can contradict me if I say something that's not accurate. And that was as a result of some of the public comments, as well as a result of deliberations within the committee, the Standing Committee on Finance, which considered the bill. So while there was serious issues about time constraints during the NA process, Chair, this bill is like any other bill. It went through the process. The A version is basically the proposed amendments. The committee adopted those, and then obviously report a B version of the bill, which B version is the original bill with the A list amendments. And that becomes a B bill. The Assembly approved that and then referred it to the National Council of Provinces to deal with it, and the Council of Provinces referred it to your committee, Chairperson. So that is a normal procedure. There's nothing that happened here that didn't happen in other bills. But the issues around time, everybody has their perspective on that, Chair, but I didn't see any procedural issues with the bill arriving where it is today. Thanks, Chair.
Yeah, so Dennis is no different from, say, the municipal structures bill. So in that sense, but where you are right is there's no difference between us, okay? don't think I'm saying, like I do with 75 bills, that, hey, you guys went to the NA, you lost out, it's a 75 bill, now you're repeating the same things. No, I'm not saying that, Dennis. If that's understood by you or anybody, no, it's a 76 bill, okay? So we're on the same page. Secondly, even though it's substantially different from what came originally to Parliament in June last year, I think, that is the right of the NA to do. Similarly, we can make it substantially different. We can make it substantially different from what we have now and refer it back to the NA. So there's no difference, Dennis. But I think maybe stakeholders might have misunderstood. I'm very clear. Dennis and I are on the same page. We will substantially change this bill if it's necessary. Thank you.
Thank you very much, Chair. It's just interesting then that that's really an admission that National Assembly processed a flawed bill for just to meet the time deadlines, to try and push it through before they rise.
That's what Frank said, with due respect. Frank, did you say that? Frank didn't say that.
No, I didn't.
Kind of implied it, Chair. We can all draw our own lines from it.
Right. Okay, that's your view, but he's an independent legal services.
Absolutely. Let's get on to the inputs we've had this morning. And I do want to appreciate the fact that we've had excellent inputs today. Thank you very much. There's been some well-considered inputs, and I you know, the fact is that a number of them are in agreement with each other. And I think the first thing we need to point out is the constitutional issues that have been raised. And I think Treasury really needs to respond to this. And I, of course, specifically want to focus on the one about the centralization of procurement and power. Certainly, you know, that flies in the face of Chapter 3 of the Constitution in its entirety. And it's limiting the powers of provinces and locals. And the potential for bottlenecks is substantial. Furthermore, Chair, the issue around localization and local procurement is quite interesting because, you know, how does one define local? So if you're sitting in National Treasury, local is South African. If you're sitting in Mfuleni, local is Sebokeng and surrounds. So, you know, will the centralized body look at some sort of an immediately local focus, or, you know, are we going to limit ourselves on that? It's a little bit unclear at this stage how that's going to play out. But certainly, I think the constitutional issues that have been raised are most interesting. And they were raised by almost every input that we've had so far. I think, the cost of implementation, Chair, and the ability to implement this, I think, is not something we should just dismiss, as you suggested in your comments at the end there, because frankly, I think what the NRF is pointing out is that you know, implementing this is going to have a material impact. We're going to be creating whole new departments, etc. And, you know, frankly, we heard from the finance minister yesterday, where he spoke about, you know, what's going to give, and he spoke about kind of, you know, the fact that there's not enough funding to implement NHI immediately. And so, you know, what's the point of processing the bill in its entirety if it's unimplementable? Is, of course, the question that's on every mind. It's an unspoken question that was left in the minds of people yesterday. I do think it's a bit of a pity. I think that like I say, we've had high level, really excellent inputs, and every single one of those is appreciated. And I think that, you know, we are going to spend time reading through some of the written submissions as well. I do think 140 pages is going to stretch our capacity a little bit, but you know, we'll certainly do our best to get as much information out as we can. What I'm missing here, though, Chair, is the small local businesses, the guys that this is really going to affect and impact, the guys that are, you know, providing services to a municipality on a local level, and whether they are going to be excluded out of the system. So we're not seeing those guys here today giving us their inputs, and you know, more's the pity. We do have opportunity as public participation rolls out through the provinces as part of the Section 76 process. But Chair, I do want to say, I do think that public participation process in the provinces needs to be fairly comprehensive and needs to reach out. You know, we speak about township economy, we speak about small business being the backbone of the economy. And realistically, I think we need to hear from the people in those spaces to give their inputs into their ideas and thoughts, certainly on the centralization of procurement ideas, but also on some of the other aspects of the bill. Chair, yeah, that's where I'm going to leave it for now. Again, just final thanks to the guys that have presented.
Yeah, okay. Just a few quick things from my side. I just want Treasury to understand that I don't think, well, I can't speak for other members, but if they disagree, they will speak for themselves. I think firstly, the issue of capacity and resources. Secondly, it doesn't matter who says what, okay, for Treasury. I don't care. It could be somebody on the right of the political spectrum or here on the far left. Doesn't make any difference. If they're making sense to me, I will agree with them. So, you know, I do think that the presentation you gave us last week was pretty thin, actually, compared to what we're listening to now about the changes the NA affected. Substantially different. Thirdly, this is a question put to the stakeholders. Now, the system is like this, right? You can be given a minute or two to reply. I regret not more than that, but don't see this as a single public hearing. We'll carry it over to next Friday, and if need be, we'll have another session after that, okay? But you have to make yourself available because Parliament is closing. The NA rises on the 28th of March and we the 3rd of May. And there are discussions at the top about this process and the need for further sittings and so on. So we will have another sitting. So please note the questions being put to you. But in this case, if you listen to Dennis, he's not really putting questions to you. He's really adding to what you're saying, from what I can gather. I think that I just want to make some general points. There needs to be a balance between consultation with stakeholders and civil society and Parliament's ultimate right to decide. I've covered that question. And you have to recognize that. Also, people do have choices. You can vote for another party, as you well know, if you don't like what the ANC majority does in the House. Or you can also stand as individuals, if that's still possible. I don't know what the deadline is, on the issues that you feel strongly about. What I also know is that people are opposed to this bill from different sides. So they don't share common goal. They are anti-transformation people who oppose this bill simply because they're not committed to transformation. Then there are people who are pro-transformation and they're committed to it because they're committed to transformation. In between are varieties along a spectrum. So the other thing to say is that in general, from 1998 onwards, we've been very cautious of the Treasury about giving ministers too many powers. Because you see, in our experience with the Municipal Systems Bill, those of you who are councillors might be interested, we were not happy with the amount allocated to a minister to regulate, especially as we had 3 spheres of government. So we said, no. What happens is with departments and ministers, if they're not sure they can get something through, then they create a generic clause in the bill. We adopted only for them to use regulatory powers to actually make quite significant, well, effectively changes to a bill. So I think you must tell us why you've given the minister so many powers, really, and regulations. I'm less sympathetic to those who say, look, I'm a local government activist, for those of you who don't know. That was my forte, if you like, my experience in the 80s, right? And I chaired local government. I'm not a finance person. And really, I'm very committed to a strong local government and the system of cooperative governance. But experience over the last 30 years and more shifted me towards saying that given what's happening in local government and given the relative strengths of provincial and national, there is a need for more intervention, precisely in the spirit of cooperative governance. And I know what happens, and all of us do, including the peasants in Mongolia, right? What goes on at municipal level. And there is a need for a firmer national framework. So cooperative governance is not some abstract sort of principle. The Constitution provides a framework for it and specific powers and functions. But within it, we can do, along a spectrum, what is possible. And I'm convinced that when it comes to procurement, you need a strong national framework while allowing a certain latitude to provinces and municipalities, consistent with the Constitution. So we'll disagree on policies there, not so much constitutional issues. On the constitutional issues, please, National Treasury, sort these issues out. You can't bring us a bill that's not constitutionally fine. You brought the bill to Parliament. Parliament said it's fine. The state law advisor said it's fine. But now you substantially changed it, right? Through agreement and or on the instruction of the NA committee. So now, is the current bill constitutionally substantial? Can you give us an opinion on that, please? And Frank, you will ultimately decide for Parliament. And if need be, we'll have to get an outside consultant, right? I'll leave it there. There's a lot more to say. I'm very worried, Treasury, that the people who are making these submissions so far are actually quite substantial in what they're saying. I'm not concerned that they're professors. They could be ordinary workers. It's what they say that matters. A professor is irrelevant, actually, to the substance of a bill, ultimately, though the ability to research and study and so on gives more substance to what they're saying in technical and academic terms, doesn't mean that politically is right. And finally, when you look at a bill as a stakeholder, you're looking at it from your point of view, but you also have to understand the political goals of the government and the majority party. So you can't separate, when you look at a clause, from what is it that the majority party is seeking to do. And so you can't look at each clause solely, wholly, and completely from the perspective of your mandate, your terms of functioning and your goals. And some of what you're saying could easily be tweaked and turned around if I say to you, these are the goals, and it's making sense from that point of view. So think about that too. Right. As I said, I think in Kulileko, let's keep the door open for a third engagement soon after the 8th, that Friday. We can even meet on the Tuesday evening and so on after the House sits, because we have to vote on bills. We'll find the time if need be. So now we are where we are. We've got 6 minutes left. And I mean, can't I just give you each 2 minutes? We'll spill over, colleagues, comrades, beyond 1 o'clock. There's no choice given the complexity of the bill and the quality of the submissions. So can I suggest each of you, please stick to 2 minutes, and really, if you take more time, you're going to cut across other people's times, including the second block of submissions that are pending. Fine, let's go for it in the order that you, and I'm monitoring you, and there's no discussion. It's going to be precisely 2 minutes. Put your stopwatches on. Right. Who's coming first in the order that you actually submitted? You know your order. I'm not going to bore you and repeat it. But in case you've forgotten, it's the Chartered Accountants. Are you still here? Nope. Okay. Then it's Public Affairs Research Institute. Are you here? Nope.
Yeah, I am here.
Well, go ahead. Your 2 minutes. Thank you.
Sure. So, I mean, I guess maybe I just want to kind of reinforce that there were very substantial changes that were made, especially to Chapter 4 within the National Assembly. And I think part of the worrying that you're seeing from much of our submissions is that we are very concerned that that chapter doesn't meet the kind of definition of a framework as required in terms of Section 217 of the Constitution. And so, yeah, just to kind of like reinforce that, we are worried about that. And it's not from a, you know, we very much are in favor of expanding preferential procurement and so on. We just want to kind of position on firm legal foundations so this can move forward smoothly. Thanks.
Thanks so much, sir. Next. Who's next? It's
Busa.
It's my friend.
Busa, thank you, Chair. Certainly, thank you for the contributions, and I'm really encouraged by the open-mindedness, and you know, just like to reiterate the fact that all comments that we've made are in the interest of what we see as a significant social partner for our own country. We live here. We also want to see what everyone else wants to. So it's not essentially a deemed to be a destructive contribution, but rather, hopefully, we hope we've come across as being constructive.
Yes,
Thank you.
You have. Thank you, sir. Okay, African Procurement Law Unit, please.
Thank you. Thank you, Chair. So just two very quick points from our side, picking up on the remarks. So I think, firstly, the matter about resources and cost, I think what is really important for the committee and the NCOP to engage with is to really interrogate the instruments that are designed in our system to assist Parliament in exactly doing that, which are, of course, the socioeconomic impact assessment system, as well as the memo, as well as PFMA Section 35. And I think all of those, as we've pointed out, are not accurately reflecting the picture under this bill. And I think it's important to just attend to those. And then secondly, in terms of the balance between what should be in the Act and what should be in regulations, I think that's also a very critical point that you made, Chair. And there, you know, of course, one cannot put the detail, or one doesn't want to put the detail into the bill itself. It will just paint us into a corner. So that is not what anyone is suggesting. But, you know, there is very, very clear international, global, you know, global North, global South agreement on how one achieves that balance in public procurement law between putting the necessary principles into your statute and supplementing those with regulations. That's very clear, Chair. And we've, you know, consistently provided that. We're happy to continue to provide that. The fact of the matter is this bill is very, very far from that global consensus on the balance between what should be in the bill and what should be in regulations. And I think that's something to really take into account. Thank you very much, Chair.
Look, here, if you can give us a 3-page summary of it, can you send it to the committee by the 8th of March?
Absolutely, Chair. No problem.
A 3-page summary, please. A pretty precise, even bullet point thing. But we can't read on that given the amount of reading we've got. Thank you.
Absolutely.
We're not going to necessarily agree, please. You understand that, right? You know that. We will look at it and see. Because we have often gone against the international norms, right?
Sure. Sure. We're just assisting, Chair.
Not like, yeah, we can use it, but, you know, it's not going to be like binding on us, but it will be taken into account for sure. We want to know what it is, give it to us. This is a big issue for Parliament, the balance between what you have in a bill and in law and the powers of a minister to regulate. It's been a persistent theme of Parliament since 1994. Thank you. Next is, what is it? It's Joint Strategic Resources. Is that right? Yes, JSR, yes.
That's it. Very much. Thank you very much, Chair. Just to, sorry, these colleagues are being ungovernable. Yeah, just to thank you very much for the process. It feels constructive and we'd be happy to participate and continue. Thank you.
Yes, okay. Thank you. Who's next? Next is National Research Foundation. NRF, yes, please.
Chair, just to reiterate what I said when I was presenting, as the NRF, we are available to assist National Treasury where they require assistance. We are an innovation organization. It's our passion, and most of our inputs, they were thoroughly researched, Chair. They were not thumbsucked, and we believe that the bill should provide an opportunity for new entrants into the market. The bill should seek also to address some of the challenges that we are having as a country. So we are available as a NRF to assist where our assistance is needed. And lastly, Chair, thank you, and thank to your committee, and a special thank you to Mr. Mangweni. He has been really of a great assistance. Thank you.
Yeah, he's great. Yeah, he's great. You don't have to tell me. He's great. I hope committee members fully appreciate how great he is.
Thank you, Chair.
Been stressed out with some of your requests, but not you. Not you. He's wonderful. You know, I always feel he's my boss. Not that I'm his boss. Not that I'm into that word. So I fear him more than he fears me. All right, good. Right. Over then to Kosatu. Oh, boring old Matthew. But now there's somebody interesting you have sucked to, eh? Yeah, right. At least we got somebody new, Matthew. We're tired of seeing you. And you're tired of seeing me, but I'm off the screen soon. Right. Okay. Over to you, Matthew. And we've done very well. We're at 11:01, even though I netted a bit, right? We're doing very well, Kululeko. Aren't you impressed with your chairperson? Okay, sorry, colleagues and people in society. I know Matthew, you know, and we all do. Matthew's more active in this committee than some of our members are. He's here all the time and he's great. Okay, over to you, Kosatu and Saktu.
No, thanks, Chair. Yeah, no, thanks for giving us space as COSATU and SACTU. So it's a joint submission. So
Matthew, can I just raise something in fairness? Right? I meant to say this earlier to NRF and others. I know you thank us for letting you speak, right? And it's a courtesy. But substantially, there's no need to thank us, as you know. This is your parliament. Whether we agree or disagree with all of some of your submissions, this is your parliament. It's not something that we're doing as a favor. We're obliged to do it because of our political views in the first place, Dennis. That constitution didn't come before our political views, and we substantially shaped that constitution for public participation. So the constitution came in 94. It's in the late 80s that we began to shape our perspectives of parliament. So we do it because of our political views, and we also do it because it's constitutionally and legislatively required, again, flowing from the majority parties' perspectives. I'm not asking you to therefore vote for us. I just want to make that clear. We do it because we think it's correct, we believe it's correct, and because we required in terms of the law to do it. So we're not doing you any favor. And we thank you very much for coming. And those of you who can stay, please do. We often encourage dialogue between stakeholders, like we'll do next Friday. One stakeholder can respond to another and so on, to the extent there's time. I think next week also, in Kulileku, we should have it from 9 to 1. Okay, now at 12 o'clock, I hope, Mama Rakhane, if I'm exiting, because I have no choice, you will take over chairing, because we won't finish by then, certainly. Okay, over to you. Don't thank us now. You don't have to thank us, please. Let's save the time.
Sure, no. You've disempowered me here. I was about to thank you. Thank you again. Perhaps it's because I went
on now. What you say?
Right, here we go. Look, no, I think so. Simon will take us through the first half, and I'll do the second half. We'll be, within the 10 minutes.
12 minutes. Yeah.
I think, Chair, why this bill is important for COSATU, for our affiliates, is because, well, number one is that we want to save local jobs and local businesses and see how to, create and support them. And also, of course, if, the state bleeds money because of corruption, wasteful expenditure, that again has an impact upon workers across the economy. So yeah, Chair, and I think we do appreciate, because we have been given a mandate by the peasants and the proletariat of Mongolia, and they're always keen for us to share our views with the esteemed leader of the Vanguard Party. But let me hand over to Simon to take us through the first half. Thanks, Chair.
You are penalized 2 minutes for that, Matthew, but let's go on.
Greetings, Chair. Greetings to the honourable members. We're going to kind of race through it. Some of it's been said before. We'll try and sort of tailor some of what we say to capture new elements of it for your interest, but maybe also just for the kind of insight into some of the risks we see. And so I'm going to probably, if I'm able to give you a better sense, the two risks, the constitutionality issue, some of the other colleagues have addressed already, and then some of the interpretation and operationalization risks. I'm going to spend a little bit of time in the first half of the discussion talking through some of those in a practical way. The step we want to propose, or the way forward we want to propose to you, is essentially a two-step process. Number one, we're providing some comments and proposed changes to the text in the bill, and you'll see that in the written submission. We're not doing it here, but in the written submission, you'll see we've provided textual changes. And then we're suggesting sort of a belt and braces approach that the NCOP insists on a post-bill process. Essentially, the bill goes to NEDLAC very soon. We're saying within the next 6 months to really have the proper engagement, to tighten things, etc. If my lovely assistant can go to the next slide. Thanks, lovely assistant. The key insight there, that the big changes coming out of the National Assembly process we think have created risks, and we need to address them. Lovely assistant. Okay. So there's the issue of constitutionality. We won't drive into it, but the headline is the following, that some what seem like fairly basic and constitutionally mandated issues appear to be missing from the bill now. And in that context, with a lack of clarity around pricing mechanisms, etc., the potential and what looks like real serious breach of the Constitution opens up serious litigation post once the bill is signed, and that's just going to drag things out and become crazy. So we obviously you don't want a Pyrrhic victory, obviously where you get something and then you lose it in the end. So we've got to address it up front, and we ask the NCOP to take it seriously. And certainly, Chair, that's the signal we get from you, lovely assistant. Over to you. If I can spend a little bit of time here, look, the bill just seems the new changes to Chapter 4 particularly seem really opaque. Scratching head type opaque, misinterpretation opaque, deficient opaque, really hard to understand what's going on. So we're trying our best effort, but we do think that the risk of what the new drafting is going to lead to chaotic implementation, contestation, uneven application. This official interprets it like that. That one interprets it the next way, even within the same unit. Across institutions, there'll be different interpretation. And what are some of those things? Well, some of the definitions of the basic tools in Chapter 4 seem to be missing. Set-asides, pre-qualifications, designation, complementary goals, etc. How are these different? Well, a common sense approach tells us how they're different. But of course, common sense may differ according to institution and person. On what basis are decisions being made about selecting one preference now or another preference later? Is there a logic? Will they be competing? Will they undermine each other? How do you prioritize them? How do you layer preferences on top of one another? How do you sequence them? How do they interact? None of that is clear, and I'll take you into the risks of that in the next slide. Lovely assistant. So we've put together just a couple of big risks. I think the last one seems to be missing from there, but so I'll add one that's not on the screen. When there's not precise instruction, and when the state obviously doesn't have the advanced capacity to both interpret and execute, we see a huge problem with implementation. So in other words, cause and effect policy objectives we think will be undermined. Some of this will take a degree of intelligence in the state, knowing what's happening in the national supply base. You want to select some kind of suppliers for set-asides, for preferences, for subcontracting. How on earth do you even know they exist? Now, some parts of the bill create a duty, for example, with designation for there to be market research, but others don't. So on what basis will decisions be made, and how, when those decisions are made, are there not going to be negative effects and compromised service delivery and misaligned preferences? In terms of the layering, let's say, for example, you've got set-asides, pre-qualification, designation, and subcontracting. How do you layer them? In a department, one may choose to layer these preferences differently within one contract to the next. But of course, what that does is it carves up units of contracts at cost and at the unit level into such small opaque levels that businesses become unsustainable. So it's not really a mechanism to build businesses, to build continuity, and our interest is less the businesses and much more the jobs and the industrialization on the back end of that. So if we're carving contracts into the most tiny units, how is that going to be good for businesses? How is it going to be good for jobs? And we don't think it will be at all. But the same exists when you carve it up across institutions. So, it may be at the moment, we know many manufacturers, black-owned manufacturers who compete in the government tender market, and they've got a sense of security. Well, the following rules apply against different institutions. But when different institutions start layering set-asides, pre-qualification, local content, subcontracting in the most arbitrary of ways, suddenly the ability to predict the market, respond to the market, and get scale and longevity and localization and jobs and industrialization, that all falls away. We think the more the process becomes complex, the more complex it becomes, the higher the barriers to entry will be, and that's going to fundamentally undermine industrialization, fundamentally undermine jobs. And we think that as legitimate businesses start pulling out, we think it's a space for tender riggers to get involved. So we think there's going to be the effect of, in fact, more fraud as a consequence of the chaos. And we just want to flag that for you. Our submission does make proposals on the textual changes, but I won't take you through that. Now I'm going to hand over to my lovely assistant. Thanks, Chair.
Okay, but thanks, Chair. I think if I'm right, we've got about 3 minutes left. So let me just gallop through it. There's just a few slides left, Chair. Members, so I think some of the additional issues into what Simon had said also
actually got 12 minutes, right? You keep saying 10, but if you want to take 12, fine.
Okay. No, thanks, Chair.
Got 4 minutes left now.
Okay, cool. No, thank you. So, Chair, just on the issue of automatic exclusion of bidders, we had a lot of discussions on this issue at NEDLAC. I think it was good discussions, but during the National Assembly process, the Section 13, which dealt with it, we feel was watered down. It had originally prevented leaders of political parties, for example, and other related persons from submitting bids for tenders, which we had supported. Just given the challenges we faced across the state. So this exclusion was removed, and we think we would want to motivate for it to be reinserted, just as part of a basket of anti-corruption measures which we have been calling for as organized labor for some time, and just given the scales of the challenges we're facing across the state and society, and the sense of alienation by ordinary citizens with regards to the political establishment, all inclusive. Then, Chair, we also had issues around boosting steps to ensure integrity and transparency. So the bill does require public institutions to keep a record of automatically excluded persons. So that's good. But now, how to make sure it has life, it has meaning or value in implementation. So we think, to enhance the transparency monitoring, we should really avoid this clause just becoming one on paper, becoming redundant, and the data just simply dying a quiet death in some folder in an obscure department. That there should be a national register of all these persons who have declared their interests, and that should be kept at the Public Procurement Office, and it should be publicly available on the website, etc., so that the media can check it out, so political parties could check it out, society, etc., because we do think that transparency is really the most effective tool against corruption and so forth. Then, Chair, just in terms of the legal concordance for transparency, so obviously members would know that about late 2022, Parliament had done a lot of work around the grey listing, the Money Laundering Act, in the G law. So there's just a need to fix some typos. We feel that otherwise it's going to create a bit of a mess. So we think there's a very basic factual error to correct in Section 33, number 2. And this is important in terms of having the effect of impacting transparency and the disclosure of beneficial ownership. So in the G law, there's a lot of good work done on beneficial ownership, but we just need to make sure this bill is synchronized with those definitions and it's in line with it. So basically, just to align the provision with both Section 56(7)AA and 56(12), we think that is missing in terms of the Companies Act. So again, it's an important thing, but not too difficult, but important nonetheless. Then, Chair, just getting lastly, so we had a lot of discussions, second lastly, on the issue of whistleblowing. We have made proposals about at NEDLAC and at the National Assembly that given that public procurement is a larger source of procurement in the economy, many institutions, public procurement became the epicenter of state capture and corruption. How do you really change the game? How do you really make those who still become the hunted? We thought a simple way is to incentivize whistleblowers. So if Honorable Karim sees a corrupt tender in the State Department, the state recovers that R1 billion, then we should give Honorable Karim or Joe Soap a reward, just trying to incentivize people to expose corruption. Because often also persons take great risk when they blow the whistle. Their lives are at risk, they might lose their jobs, they might have to relocate, go underground, etc. It has been used in the United States.
30 seconds.
Okay, cool. I'll wrap up. So I thought simply at that point to add an enabling clause to allow it. Then on the consultation, Chair, I think Simon has said we had a lot of discussion in NEDLAC. It was a bit rushed, given the time frame pressures. We're concerned, I think, as other colleagues have mentioned, about the unintended consequence of Chapter 4. We do think it needs fundamental redrafting. So proposal, Chair, is that if it can be done now, great. But if not, let's have a process immediately after elections for an amendment bill to further clean things up. And then, as Labour, as business, I'm sure we'll be keen to assist in NEDLAC. But I think lastly, Chair, we want to, motivate members that in the handover report of the committee, that supplementary amendment bill be part of the committee's handover report, and that Treasury, be obliged to make a commitment to come back to NEDLAC and let's have further discussions about how to strengthen, clean up, and enhance the bill. So let me stop there, Chair, and hope that assists. And we won't thank, but we appreciate honourable members for giving us space, Chair. Thank you.
All right, we've got Corruption Watch next. Is that right?
That's correct, Chairperson. Motlatsi Komote is here.
Thank you,
Go ahead,
Chair.
sir.
I'm just uploading my presentation. Sorry.
There you are. Yeah, we got it. Thank you.
Okay. Thank you very much for this opportunity. My name is Motlatsi Komote, and I'm a legal researcher at Corruption Watch. Just to start off by saying that I will be speaking to various things in this presentation, one being an introduction about who we are, followed by the legislative reform and objectives of the bill, followed by public participation, preferential procurement, transparency measures, independence of the PPO and PPT, anti-corruption mechanisms, incentivized whistleblowing, and some recommendations that we have. So firstly, Corruption Watch
I suggest you skip the part. You've been here so many times and we know it. Focus on the substance. But if you feel strongly, go ahead and explain who you are.
Okay, thank you, Chair. I'll try and summarize it in a one-liner. We are a civil society organization that has a focus on anti-corruption. So in terms of the legislative reform, we note first and foremost that in the 2022 and 2023 period, accounting officers and authorities in South Africa managed an estimated expenditure budget of 3 trillion in national and provincial government. And it's quite important for us to note this based on some of the legislative reform that this bill seeks to achieve. As Corruption Watch, we are of the view that Section 217 of the Constitution obviously lays out an imperative on public procurement, where it's meant to be a fair, equitable, transparent, competitive, and cost-effective system. However, we have some concerns around this because we have found that in this current version of the bill, these principles were actually not articulated both in this version of the bill and in the previous version before the National Assembly. And we believe that a large bulk of this has been left to regulations and subordinate legislation. And we feel that any policy principles of this nature should actually be embedded in the primary legislation. So we just wanted to reiterate that the risk with not doing so is that then we are vesting too much discretion in a minister without offering any guiding principles in the bill itself. And then just to note that there have been some public participation issues that we have identified as Corruption Watch, mainly with the National Assembly process. Towards the end of last year, there were some significant changes that were made around Chapter 4 in particular, which raised causes for concern for us, particularly with regards to the fact that we'd made various contributions, and it appeared that many of our submissions were not actually considered as the various stakeholders here and in the NA process. Secondly, we believe that the National Assembly had actually abrogated its responsibilities to the OCPO, who then only responded to 36% of the inputs that were made by the various stakeholders. In terms of public involvement in the facilitation thereof, members of the public are supposed to be given a reasonable opportunity to influence the decisions that are taken in Parliament. As I've noted previously, there were substantial changes to Chapter 4, which had an impact on public participation and the overall realization of rights that came towards the end of that process. And we felt that we did not have enough time to engage on that particular chapter, and therefore we recommend that it is taken back to NEDLAC for further consideration and adequate stakeholder engagement. When it comes to preferential procurement, we are not preferential procurement experts. However, we note that the insertion of sections into Chapter 4 by the National Treasury during the NA process as problematic for a wide variety of reasons. One being that the removal of price as criteria for evaluating tender defaulters will create a situation where there will be unnecessary inflation of costs, which may also increase corruption and affect the economy. Secondly, it does not cure the dilemma of whether the goods are to be procured for the lowest cost and whether it will prioritize transformation, which is a long-standing dilemma that we've found. We therefore call for the reinstatement of price as a criteria for evaluating tenders. Now I will go to the transparency measures. So in terms of the transparency measures in the bill, the PPO will be able to determine by instruction measures for the public, CSOs, and media to access procurement processes and so forth. However, we as Corruption Watch actually caution against a reliance by the PPO on the provisions of the Promotion of Access to Information Act as a method for accessing this information. We believe that lawmakers have actually missed the opportunity to incorporate the crucial principles of open contracting in this bill. This is an approach that has been adopted as an international practice in many countries, and we think that it's largely important. I think I'm not doing well for time, so I'll quickly run through my presentation. In terms of the independence of the PPO and PPT, we as Corruption Watch had previously identified in our NA submission some key areas that we were concerned about. One mostly being that there needs to be a separation of the PPO from National Treasury, and we had noted that this is something that is still a gap in this particular version of the bill. This would enhance professionalism in procurement, ensure that there's fairness, legal compliance, and would strengthen overall the checks and balances and prevent any political interference between the two entities. I will skip forward to the Public Procurement Tribunal. We think that there needs to be a lot done in terms of the appointment procedures, in particular based on our observation of what has happened at state-owned entities. We think that there needs to be an established appointment committee. We advocate for transparent shortlisting and appointment processes, specifying at least a minimum tribunal member for accountability. We note that currently the bill does not provide or speak to a minimum number. It just provides a list of the people who form part of the tribunal. We need to review decision-making mechanisms to include fairness and accountability. Okay, next slide. I will deal with some issues that we've noted around debarment and information disclosure. The current version of the bill decentralizes debarment in terms of what we've noted. The function is now extended to local governments, which would send information regarding debarment to the PPO for inclusion in the central register. There are also a number of areas of uncertainty around the provisions of debarment. One being whether or not Section 15.3 is an open or closed list of grounds for debarment. Secondly, whether it is the responsibility of the procuring institution to oversee the debarring of a supplier. And thirdly, what standard of proof would be required for this process? Again, we caution against the reliance on the Promotion of Access to Information Act as a method for accessing information. The Act in itself often imposes cumbersome and time-consuming processes that are not conducive to the fast-paced procurement space, which often requires swift access to information. On incentivized whistleblowing, we as Corruption Watch have engaged with the Department of Justice around proposed changes to the whistleblowing mechanisms. We call for incentivized whistleblowing to be included in this version of the bill because it prevents fraud, corruption, and bid rigging in particular at a local and provincial level, but also then ensures that there's early detection. And we have noted that incentivized whistleblowing has been incorporated in various jurisdictions, and we as South Africa should ideally follow suit for a wide variety of reasons. In terms of our recommendations in closing, one, we recommend that we incorporate incentivized whistleblowing in this version of the bill. There needs to be a separation of powers between the various entities within the bill. Meaningful public participation must be considered throughout the legislative process in the NCOP. Any progress that was made in receiving public input should not be lost. Fourthly, Chapter 4 of the bill should be reconsidered, particularly with regards to material provisions such as the issue of price and what criteria determines cost effectiveness. Access to information does not mean a reliance on PIA as a method for accessing information, and that should be resolved in this bill. Issues surrounding debarment should ideally be resolved, including aligning debarment with a tender defaulter provision in PRECA and dealing with any areas of uncertainty. And then lastly, transparency, accountability mechanisms in the bill should be strengthened, such as requiring policy transparency and open data for the full procurement lifecycle. And with that, I thank you. I tried to speed through it. Thank you, Chair.
No, you've been very good. You've been very good. You're under 10 minutes. Thank you for that. But you covered your points and your slides are very clear. Thank you very much. Okay, so who's next? Public Service Accountability Monitor, I think. Are you here? There you are. Thank you. Over to you, madam. Is it Lisa Higginson, I think?
Yes.
Thank you. Go
Here,
ahead, please.
thanks very much. So good morning, Chair. Good morning to the committee members and other stakeholders on the platform. My name is Lisa Higginson. I'm Budget Advocacy Coordinator at PISA. We're a civil society organisation based at Rhodes, and our interests and activities include research, monitoring, advocacy, and capacity building. I'm just saying that briefly because our presentation today is focused on transparency. I can drive this. Because our interests involve procurement reform, but also the ongoing monitoring of procurement in different contexts. So just briefly on our outline, we would just, as I said, we're focusing on transparency provisions, and these relate to sections 30 to 33 of the bill. We'll just go through some of our overviews, our concerns and past submissions. We just want to briefly discuss or explain some of our concerns based on the existing instruments related to transparency and data, briefly demonstrate how the bill doesn't adequately address these, and then introduce the open contracting data standard as a principle that could be followed. So our main arguments here is that, currently there's not enough information, procurement information for monitoring. And the bill, although it makes some really positive recommendations or has some provisions that have improved what we hope will improve transparency, it still leaves key elements of reporting and disclosure to regulations and instruction notes, which haven't been effective in the past. We don't think that this is controversial. We don't think there's a justification for leaving these important provisions to the regulations. So our recommendation is around adopting a data standard and strengthening the transparency provisions in the bill. So just briefly, we've been following the bill for some time. We've made individual submissions and submissions with our partners. There's links to these submissions here, but briefly, we've emphasized the participation process, institutional arrangements, and transparency. We don't feel as though these suggestions have been implemented in the revisions of the bill. We refer members to these submissions for further detail. So briefly on the current arrangements, we have the e-tenders portal and the central supplier database. We know that National Treasury has committed to open contracting and has committed to sharing more procurement information. However, the e-tenders portal, from our experience, is not up to date. It doesn't provide sufficient information for monitoring and oversight. So when we look at the procurement plans for basic education, for example, we don't see anything in 2024, which we would expect to see. When we're looking for information for Makana municipality, we're looking for specific projects. There's no data at all uploaded for the municipality, and so on. So we understand that there were proposals in the past to link these databases, and we don't think that this functionality has been achieved. We also note that on the e-tenders site, it actually says that local municipalities and public entities are not required to publish. And research has shown that many entities and local municipalities are not publishing their data for various reasons. Some of them around capacity, resources, equipment, and also simply because they're not required to do so. So we asked the question in our submission where the bill really can overcome these challenges. There's a proposal for a central portal. There are provisions for the type of information that should be published. But from our understanding, it still relies on the minister prescribing the details or instruction notes, which have, as we've stated, haven't been effective in the past. So we have made some more specific recommendations in our longer submission of how we think that these provisions could be strengthened, but we really would like to just urge the committee to consider whether these are realistic, whether these new systems can be implemented, and how they will be different from the existing measures. So what we've come across in our research is the Open Contracting Data Standard. This is developed by the Open Contracting Partnership. And there on the website, it's the leading international standard for publishing information about the planning, procurement, and implementation of public contracts. We note there that over 50 countries around the world publish their contract data using the OCDS, and this includes countries like Mexico, Malaysia, Colombia, also Zambia, Uganda. There really are a number of examples. It's the OCDS describes how to publish data and documents for the procurement of goods, works, and services, and it's quite flexible and adaptable. The OCDS increases transparency, deepens analysis, and facilitates the use of data by a wider group of stakeholders. We don't have time to go into the detail, but there's a growing body of evidence to show how countries who have adopted this sort of data standard have seen improvements in their procurement system. We argue in our submission that it promotes competition and inclusion, supports effective spending analysis in the interests of equity and social justice. Open contracting prevents corruption and combats corruption, and can improve service delivery and efficiency. The last point there is why OCDS and not some other. I mean, we're not being prescriptive. We're not saying it has to be the OCDS, but the argument is just that this is a tried and tested standard. It overcomes a lot of the challenges that have been raised around transparency in relation to confidential information. These are all matters that have been addressed in the various countries where the standard has been applied. So our argument is that this isn't completely new. There are examples that we can draw from, and that the end goal should be the publication of sufficient procurement data to enable citizens, oversight bodies, and others to monitor for various reasons, whether that is to determine whether the preferential procurement has been effective with achieving transformation, whether procuring entities are achieving value for money, and various other sort of processes that may be of interest. So just finally on our recommendations, we would like the concerns raised in our previous submissions to be addressed. Of course, we recognize that they won't all be addressed, but we have tried to make ourselves and our partners have tried to make suggestions for amendments to the wording of the bill that we think would make it more effective, that we hope would strengthen the transparency provisions. And we recommend that the OCDS or similar is adopted. And we make a note there that as far back as 2014, National Treasury had showcased spend data visualization. So some of this data, we argue, actually already exists, but it's just not being published. And the last point there is to align with the DPSA government-wide open data principles. I'll leave it there. Thank you very much for the opportunity.
Thanks. You didn't use all your time either. Next is Samet, Medical Technology Association. Are you here?
Yes, Chair, they are here. Tanya?
Samet?
Yes, we are here.
Okay, go ahead, please.
Just trying to share my screen. Here we go. Yeah, there we go. Are you able to see my screen?
Yes, please go ahead.
Fantastic. Thank you so much. Just by way of introduction, SAMED is the South African Medical Technology Industry Association. We were founded in 1985, and we are a not-for-gain voluntary industry association committed to enabling sustainable, ethical, and transformed medical technology industry that advances patient access to medical technologies. SAMED provides a voice for the South African elective medtech and in vitro diagnostics industries. We've put together our presentation, Chair, just to focus on, I think, some possibly different aspects of the procurement bill that we'd like to highlight to the committee. Areas that we intend to highlight in both our presentation and in our submission focuses on the consideration of how procurement in medical technology poses a very unique challenge, and how a one-size-fits-all procurement plan could raise significant issues in regards to patient care and taking care of the healthcare sector in general. We want to advocate for consideration of value-based procurement in healthcare and the issues that are being raised by removal of bid specification committees by the current draft. The removal of strategic sourcing has also become a significant concern within the medtech environment. And there are also conflicts between the proposed procurement bill and that of the NHI bill, as well as the medical device regulatory frameworks, which are of concern to us. Just a little bit about the sector. I know medical devices often gets lumped in with the medicine, so just to highlight the differentiation. Medical technologies are estimated to bring in approximately 20 billion rands in terms of the market size within the country. Over 80% of those businesses are small and medium-sized enterprises. They are not multinational dominated. Majority of our products are imported. A lot of that is due to the challenges that raised with the significant amount of technology that is required, the large investments that are needed in terms of manufacturing, distribution, user training, and education. Products range from something as simple as a tongue depressor to something as advanced as an artificial heart or an artificial limb or internal implants. Most of our products bring added functions and clinical value through incremental improvement in these technologies. Our life cycle in terms of our products within medtech is very rapid. We're looking at kind of an 18 to 24-month period rather than the years that are experienced within the pharmaceutical environment. This continues in rapid innovation, and it is imperative to consider when you're basing new science and new technology and new materials when you're looking at a procurement plan. Excluding these could result in significant limitations to our ability to care for patients adequately, and it will limit South Africa in terms of its exposure to international technology and international examples of best practice. For the successful implementation of a procurement bill, the industry certainly feels that there's a need for very wide engagement across various ministries and agencies. In accordance with the Medicines Act and the Medical Device Regulations, subcontractors in this space would be required to meet the same requirements as manufacturers or multinationals or larger businesses, which could potentially land up increasing prices of devices ultimately to patients and to the government sector. The NHI bill proposes a procurement system which runs parallel to the procurement bill. NHI proposes the use of a centralized procurement system. Such a system, unfortunately, does not allow for the nuances that are required in the procurement of medical devices. It ultimately will prevent healthcare units from procuring the required equipment to effectively treat differences in demographics, disease burdens, prevalence in an area, nor will it allow for the required technical support, equipment, spare parts, and training that may be needed. Many goods that are procured within the space are patient-specific, as such as an example of surgical implants, which can only be determined within a surgical environment during an operation. It also doesn't allow for competitive bidding, which is in contradiction to how the procurement bill is structured currently. Provinces and healthcare establishments under NHI will lose the ability to procure, which will prevent healthcare units to provide adequate patient care due to the removal of their rights to decide which medical devices to have or to use, depending on patient need. Which we need to take into consideration in ensuring that patient care ultimately is placed at the forefront when dealing with healthcare procurement. A lot of when we talk about centralized procurement, there is a lot of concern that I think was highlighted where this became an issue during the COVID-19 pandemic. It highlighted South Africa's dependency on imports and the need for a local manufacturing structure for a resilient healthcare system. We need to understand that medtech is not a commodity. It's not a box of paper that you buy to buy for your printer. And there are rapid cycles of improvement and significant clinical variations in the products that are procured. And we have to continuously consider the innovation in that technology that has to be considered to ensure that we keep up with the levels of patient care that are being seen globally. Medtech is a very complex sector. We have various subspecialties of devices, bespoke products that are made per patient need. As delineated as a specific prosthetic for a specific patient based on that patient's MRI or X-ray scans. We have to be very, very clear that in the medical space, low cost is not always necessarily the best value. We need to make provision in the space for outcomes-based decision making. And also non-exclusive contracting to allow for participation of multiple models and types so that we can avoid having a single supplier model will be very, very helpful. The absence of a legislated framework that relates to supply chain management and the way in which the bid specification committees work. We'll continue to see instances where inappropriate products are procured, inappropriate implementation of contracts, healthcare professionals with products not working as they should, and ultimately it'll lead to suboptimal health outcomes, as which we saw with the procurement challenges during the COVID-19 pandemic. A procurement system that considers price as the predominant factor will fail to account for cost and value over the entire episode of care, and will tend to favor older and simpler technology. And as such, this may eliminate new and innovative models with benefits of meeting different clinical and patient needs with better health outcomes. We need to consider a range of different medical technologies that is often needed to achieve flexibility in treatment to cater for different patient needs and the varying experience levels of clinicians. Many conditions require the availability of a variety of devices. For example, patients differ in size, age, their comorbidities, and may require specific devices. These need to be considered in a procurement plan, and alternatives need to be available to patients. Medical devices often remain implanted in a patient or in use at a hospital for many, many years. Much of the cost and economic value of a medical device is not only the purchase price, but it considers the quality, service, technical support, training, and education provided by the supplier, and the value that it adds to the patient's life, their quality of life, and their life expectancy ultimately over the years. In the case of something like an implantable device, much of the service and support comes post an implantation. Additional hospital procedures to replace or adjust low-quality devices add greatly to overall costings. And to be cost-efficient, a procurement process has to take into overall account the duration of the patient's clinical condition. It's not a one-size-fits-all structure. The concept of value-based procurement, which also has been removed from the draft bill and no longer exists in the current bill before the Select Committee, it sets out important parameters to ensure that medical device procurement is appropriate and responsive. Strategic sourcing has also been removed as a definition in the current version of the bill. Value-based procurement places at its core the simple value-based healthcare equation of patient outcomes divided by the costs of achieving these outcomes. Value-based procurement then is making purchasing decisions that consider how a product or solution can best deliver the outcomes being measured and reduce the total cost of care, rather than focusing exclusively on purchasing a specific product at the lowest possible price. Thank you, Chair. I think I've hopefully covered all the elements that we'd like to put before you.
Thank you very much. You also didn't use your full time, but that's good. You covered your points. That's the main thing. Stop, reset. Okay. Now we've got willpower. And then the final one from Gabriel. That's how you say the name. Thank you. Now I'm at 11:46. Hopefully, as mostly happens, I don't get completely cut off. I'll switch to my 4 or 5G. But if that doesn't work, our whip will share, which will arrange for the whip of the Appropriations Committee to chair the last hour. but I shall certainly follow this on YouTube later today. So I won't miss out on anything, and I'll see you next week, Friday. Okay, over to you, Willpower.
Thanks very much, Chair. Thank you for the opportunity. This is not just Willpower. There are a couple of people that have come together to put this presentation together. Advocate Helen Fenter, well respected in the public procurement community, particularly for her focus on local government. Professor Hiokino, he has presented, he was part of this, and myself have co-written a textbook. I've done over 20 years of training in public procurement, run a weekly webinar with 1,200 people that have subscribed to that, all public procurement focused. This particular presentation has culminated from at least 3 national webinars that we've had. The document that we put together that we have shared with the committee has also been widely circulated, and please, we would not be surprised if it does fall into some other submissions that you might see. We've summarized 10 themes with 35 recommendations. I'm not going to go through all 35 recommendations now. I will cover some of the highlights in each of the themes. The application of that, and I'm also going to try and focus on the local government provincial focus in this, which is NCOP's focus. And application of the Act, right now, Parliament and provincial legislatures just has to comply with Chapter 4. And we think that is going to continue the fragmentation, which is exactly an objective of this particular bill, which we want to try and overcome. The Act also applies to donor funding, and we're really concerned that this is going to have a significant financial and service delivery risk at provinces and local government. Donors do not want to follow the exact prescripts of a national entity, and that's going to, they're going to say no. We will rather take our money elsewhere. Very interesting. The district development model seems to have been ignored in this. It is a president's priority. And for example, one of the things that's in there is transversal contracts can only be done at a national or provincial level, but districts is an ideal opportunity for that. And that seems to have been forgotten. The constitutionality, I'm going to focus on different aspects today, and also the definition of the Act. The key thing from our perspective, again, provinces, local government, it ignores local and socioeconomic constitutional objectives of provinces and local government. Yes, it focuses on RSA from a development perspective, but it seems to have forgotten about those constitutional requirements at province and local government level. The central office, the provincial treasuries are going to issue binding instructions, but they're not going to bring COCTA and SALGA into that process. You've heard that already this morning. There are also conflicts with original legislative and executive powers at provincial legislatures and also local government, particularly Chapter 3 of the Constitution, the Intergovernmental Relations Framework Act, and also Section 5 of the MFMA. The definition of the Act includes regulations, codes of conduct, instructions, and notices, and we've included 36 matters in our written submission, which are not catered for in the bill. And that's going to make it difficult, because this says that if an accounting officer fails to take reasonable steps to implement the Act, they're liable for an offence or imprisonment of 3 years. Very difficult, Chair, if 36 matters are not there, but you are liable for the implementation of the Act, including regulations, code of conduct, instructions, and notices. The organizational implications of the central office, provincial treasuries, and institutions. The current version of the bill allows for specialist office at the public procurement office at the national level, but they just assign powers to provincial treasuries and doesn't cater for any specialist office at that level. The procuring institutions, their functions are defined, but there's no original power allowed to municipalities. And that's going to be a key implementation issue. I know we want to get this through for the elections this year, but this bill is going to be implemented just before the next local government elections. And we've got to be sure that we are thinking about that as well. There's no provision in the bill at the moment for the minimum organizational requirements or competencies or even the positioning of where the procurement office will be in any institution. And one of the things that concerns us is there's no provision for any regulations regarding the structuring of these units. Let me pause briefly, Chair. This is not an easy thing we're dealing with as a country. We're moving, if we just take the PFMA, there's one paragraph in the Act on what we're dealing with here. At the Act level in the triple PFA, it's probably 2 or 3 pages. We're going from one paragraph, 3 pages, to a 33-page document, and it's not easy, and we must recognize that point. Many points raised on preferential procurement already, but Chair, if you have a look at the one, particularly the pre-qualification stipulation that's there, it lists all the different designated groups that can be pre-qualified. Black people, people in the province, women, youth, disabled, etc. But from a regulation perspective, it says you can only choose one. Now, that's going to be extremely limiting at provincial and municipal level. They're going to have to trade off between, do I look for somebody in my province, or do I decide that I'm going to go for Black women? I can't say Black women in small businesses in my province. It doesn't allow us to do that. And that's going to be a barrier to transformation at a provincial level. Local economic content, welcome that coming back in. But again, it focuses at national level and forgets the requirements at a local, at a provincial and local government level. This has been said before, Chair, and I've followed the National Assembly deliberations in detail. I understand why complementary goals is there, and I've got some inkling as to what it might mean, but it's not defined. And this is a material term. We all understand 90-10, 80-20. But what is this term? It's very, very difficult right now to actually comment on what this means. There are a couple of procedural measures we've put that into the bill, but the point is they shouldn't be in primary law, and they're going to be limiting. One of those, just to give you a quick example, is a measure in there that just gives you one option. South Africa is already using 4 different options. The World Bank recognizes 5. The bill talks about, this might be quite difficult to understand why is this so important, but the bill talks about subcontracting, an important transformational measure, subcontracting as a condition of bid, not a condition of contract. The condition of bid, we're suggesting, is going to empower the construction mafia, the radical business forums we've got in the country, continue to create those unreasonable expectations at a local community level. It's very practically difficult to do that. And conditions of contract works. Let's just go with that. Industry alignment, the previous presentation just raised that. Chairman, if you just take Gauteng's Premier said they're gonna buy 18 private hospitals. What is the procurement implications for the provincial department of this? We need to start to understand that it's been said before, this is like 2 ships in the night passing each other, the NHA bill and this. The dispute tribunal mechanism, it's been raised before, but sincerely, one tribunal with no maximum period for resolving that is probably going to paralyze public procurement. We really need to look at this one. It's going to take 18 to 2 years to establish these tribunals. It's not a quick fix, but there's no transitional arrangement in the bill for that. We've got working mechanisms in Gauteng and KZN. Are they going to be abolished? Again, that transitional mechanism is going to be important, and it's ignored mediation as a dispute resolution mechanism. Financial and budget implications, it cannot be that there's no financial impact for the state. It cannot be. The preamble recognizes an increase in capacity of organs of state. The donor funding losses, the hidden costs of provinces, IT issues, the operating setup and operating costs of the tribunals, it just cannot be that there's no financial impact. The systems, hundreds of millions has been spent on systems at the local government and provincial level. And to think that to replace those and to roll out one single platform across the country is that going to cost anything is very difficult to understand. Paying a premium is critical. We must fund it. There's no mention of that, and it is an important. Trumping provision is going to create some difficulties. We've highlighted a couple of issues here where there are conflicts with existing legislation. That trumping clause needs to be looked at. Cooperative governance, you've heard, we've picked up 9 infringement areas identified in this. We've put that in our report. Again, just coming back to Copta and Solga's involvement in this one. And then lastly, in the last couple of seconds, the operational scope. It's brought, again, the provinces and municipalities are not going to be able to have their own local databases. It all has to be centralized. Please, the definition of a method, there are many other definitions of method, but the definition of method is missing. But then the bill includes transversal contracts as an example of that. But a transversal contract may not be a method. It might be a sub-method. It might be a contract type. Just take it out as an example of a method would be much, much better. And the bill brings in contract management, risk management, and asset management under procurement. Chair, contract management and asset management is not a procurement function. It's going to have issues in that, and just remove, and we've made a suggestion on what the provisions could be, remove the obligation to create a single ICT system for public procurement in the state. We are too diverse, public sector, to be able to use one single ICT system. Chair, there's our 10 themes, 35 recommendations. We have submitted the document. It has the detailed recommendations within there. Thank you, Chair, for the opportunity to present.
Yeah, it's interesting. Most of you in the second half haven't used your full 12 minutes. That's interesting. Okay. Because, I mean, in a way, you'll overlap quite substantially. Okay, the last submission before we throw it open for discussion is Gabriel. I'm not sure, I'm afraid, how you say that. Is it Grass?
Thank you very much, Chair. Browser is fine. And I very much appreciate the accommodation.
Sorry, are you the Institute of Race Relations?
Yes, and IRR Legal.
All right, okay.
Thank you.
Under your name, is this you speaking on behalf of them, or is it your personal?
No, on behalf.
Yeah, so it's IRR. Okay, thank you.
Correct. The Institute of Race Relations is Africa's oldest classical liberal think tank, founded in 1929. IRR Legal is a separate new entity. The IRR is its only member, and IRR Legal is a civil litigant that seeks to promote constitutional values, non-racialism, and yeah, I mean, if you want a social objective that we're really focused on, it's improving employment. Thank you very much for the opportunity to present here. I'd also like to start by just reflecting on compliments to the chair and to the committee. I think on the proceeding deliberations on February 6th, we want to look a little bit at some of the fruit that was born out of that exchange with Treasury's representative, Mr. Willie Matabula, who I think has also made invaluable contributions. I'm going to, the caveats, the usual caveats, our written submissions do a clause-by-clause analysis. We're not going to go through that here. We have also tailored our analysis to avoid a repetition where it would just be gratuitous. So the oral will be the same. Hopefully this is, mainly just stuff that to an important extent has not been covered yet. So the first point is Mr. Matabula on February 6th said to the committee that premiums are paid. He explained the premiums paid under the 90-10 system max out at 11.1%, and on the 80-20 system that's under the current triple PFA max out at 25%. His words exactly were the maximum premium paid in that 90-10 preference point system is 11.1%. So that's a premium that the state is prepared to pay to advance transformation. In terms of 80-20, of course, it's 25%. You can call that a preferential premium. You can call it a BEE premium if the policy that the preference point system is based on is a BEE policy, which it tends to be. I think it's the key point here is whatever you want to call these premiums, it's important to bear them in mind. They come up again and again. And the first place that they really come up is in section 216(1) of the Constitution, interpreting that clause of the Constitution and seeing what it imposes, what duty it imposes on national legislation. Now, if anyone on the committee knows anything about the Institute of Race Relations, anything about IRR Legal, anything about the work they do, they're going to know that we oppose race-based legislation. So, you know, you can almost take that for granted, and obviously there's not going to be a meeting of minds between many stakeholders and many members on such an issue. So let's just put that issue to the side for a second. Assume, in other words, just for a hypothetical, assume that for a moment we were willing to go along with race preferences. So we're putting aside section 217 of the Constitution and the balancing or the limiting interpretives clauses 1, 2, and 3 there. And we're saying, you know, imagine you're in a world where B is grace. Nevertheless, section 216 of the Constitution, in its very first subsection, requires that national legislation set up a system so that through Treasury, legislation around Treasury, that will ensure both cost control and transparency. And notice that difference between cost control and cost effectiveness. 217 deals with cost effectiveness. And when we get to a 217 conversation, we can disagree with each other about whether these premiums are cost effective or not. But that's a different question to are those costs being controlled or not. And our submission is that those are not, there is no cost control there, and there is no transparency there. This legislation, again and again, creates obligations and creates discretionary powers for both ministry and for procurement officers to deviate from a value for money basis, to pay what Mr. Mathebula called premiums. Now, however you want to think of those premiums, they are a cost. And that cost is not reported in the budget at present, and that cost is certainly not going to be reported under the new system of procurement envisaged by the Public Procurement Bill. And that's a major concern. And if you go through our written submission, you'll see on a clause-by-clause basis where changes could be made in order to cure this problem. And we implore the committee, you know, like even if you really can't stomach the other aspects of our submissions, please take seriously the thought that there's a cost here, and that cost has to be accounted for. Accountability literally is a numbers game to begin with. We can then get into the values game, but it starts with a numbers game. Like, tell us the numbers. And it might sound a little bit, I just want to make one more clarificatory point here. It might sound to the committee like you've already heard this from the other submissions. And to an extent, you have heard from the other public stakeholders today that there's a problem insofar as the costs haven't been accounted for, where the costs have then been enumerated or exemplified by things like, you know, the cost of hiring new staff to process the paperwork, the cost of hiring new computers or software systems, ICT, to deal with the processes envisaged in this bill. Yes, those costs are significant and they must be accounted for as well. But what I'm talking about is something different. I'm talking about the premiums, the costs that come out of, you know, seeing two different bids and spending extra on one business rather than another in order to get that premium. And we know these premiums are paid. Mr. Mathebula talked about the cap that's envisaged. We know that they will be paid under the bill as it's envisaged. And we know, you know, for example, from the City of Cape Town, did a report last year auditing a little bit of their own payments, and we saw that they were paying such premiums. So what this bill has to do, and what it doesn't do, is create a system so that every time such a cost is paid, or what the committee might want to call transformation, that cost is accounted for, and so it can all be added up, and then the number can be taken back to the public to say, look, this is how much the government has spent extra on BEE, for buying roads and toilet paper and transformers, whatever it is, and this is how much it spent to get the stuff, and this is how much the extra was in terms of that premium, to use the term that Mr. Matsabula used. Okay, so 217. Section 217 of the Constitution, we lay out, I think the committee's already heard that there's a violation here. I don't want to go into too much detail. I just want to say that, there is something for the committee to consider, which is the concept of a tiebreaker. If you look at international laws that try to deal with affirmative action, you often find that affirmative action comes in as a tiebreaker. So, in a procurement perspective, that would be the case where you've got two bids that are both equally cost effective. So you're ticking that box, which is an absolute requirement of 217(1). It has to be cost effective. You've got two companies, they're both just as cost effective in what they're bidding to tender, to sell. And then you say, well, how do we break this tie? And in a lot of legislation and regulation, when there's ties, the provision is made to flip a coin. I mean, that's a real legitimate government procedure. Flip a coin. But here's another way that you might break the tie. You might say, here's a preference point system that will be used to decide who the tiebreaker is, and the categories of persons to be protected or advanced. There's contemplation of that in 217(2), and the categories of preference will be in 217(2)(a). Will stipulate how to break that tie. This is a very serious thing that's done in other countries, and we urge the committee to consider that as a way of reconciling 217(1) and 217(2)'s requirements. If you want to cure this bill of its constitutional defects, and you want to sort of set up a framework that's going to adhere to this Zondo report's advice to maximize value for money while respecting transformational imperatives, we urge the committee to consider the tiebreaker. We urge Treasury to consider the tiebreaker. We'd really like to hear some feedback on the tiebreaker. If there's some sense of sort of why that couldn't work, I'd be really curious to know why that couldn't work. One more thing to touch on: fresh facts. Chairperson Karim, to his great credit, asked Treasury for data. I'm paraphrasing here, but he said we need to have this conversation in terms of facts, and I think that is absolutely correct. There are very different values in the room here, and hearing the political representatives on February 6th, very different viewpoints came across. But facts, we should all really be on the same page. And if we could get on the same page there, then maybe those different viewpoints would stop seeming so different after all. Maybe we could find better go forward. And one of the key facts that came out of the committee's request to Treasury to provide statistics on how BEE generally functions was that out of the surveyed roughly 1.22 trillion rand in procurement over the last 7 years, that was sort of broken down by characteristics like race. I'm just looking at the number here. 140 billion was spent on companies that's not Black owned. So, that's like just above 10%. 47 billion on companies where race was not provided. And, I don't think we should be making assumptions about what race that entails, but some people will, that's fine. And then 128 billion on companies that are partially Black owned, and then 586 billion on Black owned companies. And which comes out in terms of the, if you exclude state owned enterprises, which is another almost 300 billion, then Black owned businesses, yes.
Mr. Karim says you should round up.
This is my last point. Black businesses came out at 63% of the private businesses recorded being paid by government. That's the majority. That's quite a strong majority. I think that's a really important fact, and I think this committee needs to contemplate that fact. Is it necessary to enhance the scope of preferentialism at a stage where black business is already thriving, is already doing well, where white business is a minority that can't be exerting an oligopolistic kind of undue influence. We think that South Africa is very different today to what it was, and Treasury shows that. And we think that legislation should reflect that and be geared really towards serving the poor best, which is going to be done by getting the best bang for buck. Thank you so much for the opportunity.
Cell phone. Can you hear? Hello? Can they hear me in Kulileko?
I can hear you from my side, Chair. I'm not too sure about them. Can you?
We can
members
hear him.
hear?
We can hear him. Not very good, but we can hear.
Okay. Go ahead, Chair.
Hello?
Hi, Chair. Go ahead.
Okay, if I get cut off, I'm going to cut up to Chair because I'm not sure whether this is feasible. So now over to I'm not on Zoom. I'm via the secretary's cell phone. So he has to direct me. Whose hands are up?
We're still waiting, Chair. There are no hands up yet. Oh, I've got Mr. Ryder. That's all for now. You can go ahead, Mr. Ryder.
Yeah, thanks very much. I'm sorry, my hand was delayed because I really couldn't hear the chair. I think everyone's aware I have a hearing impairment, but yeah, great. Thanks very much. And well done to everybody. I think we're actually 2 minutes ahead of the agenda schedule. So well done, and thanks again for all of the inputs. I think Cosatu started and raised some very cogent points. You know, and the one fact that I want to pull out as well is the fact that they pointed out that Section 2171 appears to be diluted, and there appears to be an overcorrection with too strong a focus on 2172. And I think the IRR just made a similar point. And the IRR took it further and pointed out that 216 also has some very important aspects that need to be taken into consideration. So I do believe legislation needs to be balanced and needs to take all of these different things into account. And too strong a focus on one particular clause in the Constitution might leave us a little bit lacking. Cosatu also mentioned the issue around NEDLAC, and I mean, I made the point earlier, and perhaps just to emphasize it, NEDLAC is big organized business. It's a structure where kind of organized people have a lot of say, and I mean, I have my own views on NEDLAC, and I think sometimes that they are given a little bit too much power because they speak for an already advantaged and fairly small grouping. But that's my personal view. It's not necessarily the view of my party or anything else. But the point is, again, that we're not getting the inputs from the small businesses, the township economy players, the guys that are really providing services down the bottom. Again, the issue of whistleblowing was raised, and it's been raised a couple of times. Cosatu, I think, pointed out the fact that there are basic errors, grammatical errors and spelling errors in the bill before us. And I think that just points to the haste with which the B bill was bashed out with its material changes. And of course, the unintended consequences that are going to come about because of the substantial amendments to Chapter 4 that have not been properly tested. And in the very truncated timeframes that we're dealing with this, are unlikely to be properly tested, which makes it very, very difficult for us to really come out with a proper bill at the end of it. I think, right, moving on. Corruption Watch, I think, yes, another constructive inputs, mostly echoing what most other people are saying. Public service accountability. Spoke about the transparency aspect of corruption. And I think Corruption Watch also spoke about transparency and the fact that exactly what the chair pointed out to just now, the powers that are given to the minister in terms of this bill seem to be too substantial. And in fact, one considers, and I can't remember which clause it is, I think it might be somewhere in the 30s, but it says that the minister can determine the depths of oversight that happen and how open the procurement processes must be. And the minister has a say to determine, who's allowed to participate where and so on. So giving huge power, but also not giving enough oversight over the procurement process that we would like to see. Just a comment on what Public Service Accountability said about municipalities having incapacity in terms of their reporting. I think they often hide behind their incapacity. It's just a convenient excuse sometimes. Solmed, yes, pointed out the disconnection with NHI, and I think that also came out in Willpower's presentation, where they pointed out the conflicts with different bits of legislation, and it'll be quite interesting to see, which piece of legislation will then take precedence where there are conflicts. And I think Somed made valid points that sometimes, procurement is very nuanced in specialist areas, medicine being one, but I mean, there are others. And often, a cold-hearted kind of look at the paperwork that's presented is not always appropriate. Certainly not when it's done on a centralized basis in a little office in the basement of Treasury. Willpower's Mr. Scott. I think I am often accused of being an optimist and wearing rose-colored glasses. I think Mr. Scott pointed out the one good thing with this piece of legislation, and that is that it doesn't reference the district development model. I'm saying that tongue in cheek, of course, but I do think that the district development model is dead. You'll see the rhetoric coming out of even the presidency's office, where it was first born, has tapered off substantially, and I don't think that. I think all of the test models have pointed to the fact that the DDM is never ever going to work. Willpower also pointed out the financial implications that haven't been properly addressed. Then to the IRR. And thank you very much. I think that we share concerns about race-based legislation, of course, but it brings us to how these things are going to be tested. And I've asked the question before: will we revert to the pencil tests to determine who's black or who's black enough? Obviously, in terms of the changes that have been made to the Marriages Act and the Group Areas Act and so on, race has become quite a fluid thing, and of course, how do we evaluate who falls into what category? What's stopping me from self-identifying as a black woman, for example? But I think that there's massive difficulty with any race-based legislation. Not only in just defining it, but again, repeating the overfocus on 2172 in isolation without reference to 216 and 2171 and others, and spoke extensively about the premiums. And I think that no one's mentioned the Harvard Growth Labs research and the IMF's research, which indicate that preferential procurement is often counterproductive. And in fact doesn't have the intended outcomes that are hoped for. And I think Honourable Willie Okamp last week, in the previous engagement, it wasn't last week, it was on the 8th, made a very cogent argument that government is supposed to be helping the masses. The best way to help the masses is to provide services cost effectively and efficiently, and at an appropriate, quality level. The best way to do that is to make sure you get the best person to provide the job at the cheapest rate. This bill does exactly the opposite. Thank you very much. I'm done.
Hi, members. I've lost the chairperson once again. While I'm trying to reconnect him, I think the process was that stakeholders were given 2 minutes to respond to the points raised by Mr. Ryder. Can we start with COSATU while I'm trying to connect the chairperson? Thanks.
Sure, we can, and thank you very much for the comments, but also to the other presenters and speakers for some really thoughtful insights. I just want to I'm going to respond to the Honourable Rider just through a little bit of a high-level set of issues. First one is it's a really major bill. I think there's agreement on that, and I think there's agreement between all the colleagues, and obviously with the caveat from our honourable colleagues at the NCOP. That they may disagree with us, but there is a sense that there may be some challenges here that need to be looked into. Look, what we want you to do is we want you to fix it, fix the challenges, but we also want you to go back to NEDLAC. And that's regardless of whether or not it's fixed or not. Now, here, Honourable Rider, and the concerns around NEDLAC, I want to assure the Honourable Member that, in fact, trade unions like my own have members in SMMEs, including Black-owned SMMEs, including often informal businesses. And so there is a degree of understanding of the challenges that are faced, but that at a high level, NEDLAC really is a much more functional space to debate policy than a nothing. And so I want to put that, while you may have concerns, let's take it back to NEDLAC, and we'll do at least a much better job than a nothing. And I say that partly tongue-in-cheek too. We want to bring it back within 6 months. Why? Well, not just because of the importance of this bill, but because of the changes that have been made and the need to scrutinize them, but also because public procurement is done really badly in the country, and it poses an existential threat to public finances, to public behavior, to socioeconomic development, to delivery, service delivery, to democracy and our social contract. When it's done badly and people see the state doesn't work, they stop believing in the state and they stop agreeing to play by the rules of the state. So we wanted to come back to NEDLAC so we can do a sufficient job. I'm almost done. Just to say one last thing. We don't have a problem as COSATU with national control over things. In fact, we've got huge level of insecurity and concern around decentralization. There are just so many things that can happen at the level of decentralization. So we are deeply concerned about that. And we see a lot of merit in national control. That includes a national ICT system. We'd be quite keen to get into a debate with the colleague from Willpower around that, if he's got concerns. But we see a need for a system that sucks up data at the local level so that there's better oversight, better ability to see problems, and better ability to respond to them. I'm going to stop there in the interest of time, unless my lovely assistant, Comrade Matthew Parks, has something to add.
Corruption Watch.
Thank you. Thank you very much. I just wanted to answer to some of the things that have been said by Honourable Rider. I think the first one is just to reiterate what I think a lot of stakeholders have said here today, and even in the NA process, which is that this bill is an important one and it should be done correctly. And I think we should not rush it through. We should ensure that the primary piece of legislation is actually one that addresses some of the concerns that have been raised previously and even now by various stakeholders around the transparency and accountability mechanisms, but also around the open data contracting as well, which our colleagues at PSAM have spoken about. And then I think also just to note that in terms of the public participation process, for us, we still reiterate what has been said by COSATU, which is that we should take parts of this bill back to, or this bill in actual fact, back to NEDLAC for greater consideration and stakeholder engagement. We think that that's the right process and way forward for us as Corruption Watch. But also just to say lastly, on the transparency and accountability mechanisms, we should not be leaving a lot to subordinate legislation, but also we should ensure that there are effective checks and balances in place for the minister in particular, because currently as the bill stands, in both versions of the bill, the minister has unfettered power, and that may actually be quite detrimental, as we've seen with state capture in particular. And so it's very important for us to learn those lessons and to take them forward and not repeat the same mistakes again, particularly at a provincial and local government level, where a lot of the municipalities are actually not performing as adequately as they should.
Thank you, ma'am. Public Service Accountability Monitor.
Afternoon, sorry. My name is Lisa Kota. My colleague Lisa has had to step off. So I just thought to make a quick response on behalf of the organization in her absence, to reiterate, I think much of what's been said around the importance of the changes and continued participation around the bill. Perhaps one point we would like to emphasize and leaning a bit on Honourable Ryder's point around ensuring that there is more inclusion of a greater number of people more directly affected by the changes or more directly affected by the potential reform that the bill would bring. I think that's a really important consideration in the context of public participation in particular. The second aspect is around the social justice imperatives of public procurement, which I think we all appreciate, but sometimes get lost in just the complexity of the field of procurement. Not unlike public finance, for instance, which is another area that has massive social justice implications if we don't have adequate and inclusive processes like this. So we would really like to reiterate the importance of ensuring that whether it is that the NCOP involves a wider diversity of inputs, for instance, not assuming that is necessarily the responsibility of this committee, but that we would like to see a much more inclusive process, of course not at the expense of finalization of the bill. Thank you for the opportunity, and we look forward to continued engagements and hopefully, as the chair has indicated, we will have some comprehensive inputs and feedback from the National Treasury.
Samet.
Hi, greetings everybody. Thank you for the opportunity to chat to everybody today. So I think from Samet's perspective, we welcome the recognition that there is definitely significant challenges between the procurement bill and the NHI bill, and where those two land in the middle. And as the Honourable Ryder indicated earlier, which of those bills will end up taking precedent. I think that's a very, very key topic that we need to have addressed. And just in terms of, and I know we keep on going back to looking at it from a health perspective, but in terms of dealing with public procurement within the healthcare space, it cannot be a one-size-fits-all environment. Healthcare is such a nuanced environment, and without having highly specialized individuals who are adequately trained with the right knowledge to be able to construct procurement budgets, right specifications, there will be a dynamic impact onto the delivery of healthcare within this country. Having a versatile public procurement space, particularly in specialized areas, is an imperative for this country and for healthcare in this country to succeed. Thank you so much.
Willpower.
Thank you very much. Thank you. And let's just quickly respond to Honourable Ryder's point on the district municipalities. Granted, it's not going well, but let's dismiss the point that there's a major gap here on cooperative governance in this, and municipalities and how municipalities lowest level are going to be brought into this is critical to address going forward. Premium is important. There's no way a small Black women-owned business in Northwest can compete with Bidvest on price. We are not there yet as a country. So premium is important, and we've got to acknowledge that. We've got to build that into this process. We're not saying that it should not be done away, but we're not there yet as a country to stop paying premium. Just on the IT point that was raised, it's absolutely acceptable that there will be a common data platform on which that data would be, to Simon's point, would be available and transparent. But don't layer on top of that a common platform that forces common processes when you're buying locomotives, power stations, stationery, medical devices, things that haven't been invented yet. It's not going to work. The problem we're going to have then is we're going to have so many entities requesting exemption that we're going to actually lose that common data platform. We've got to be very careful how we approach it. Thank you.
IRR.
Thank you very much. I agree with what Honourable Ryder said about the sort of extra points on the IMF and Harvard studies, and and what kind of procurement policy will come out of a really pro-poor, pro-growth way of thinking or target. I just want to sum up by sort of concretizing a very simple request to the committee. I'm not sure if the chair is still here, but I was so impressed by what happened on February 6th. It was amazing to see a branch of the legislature hold a branch of the executive responsible for delivering information for the public benefit. Without, I don't want to mischaracterize anything, but I think it's fair to say that, a request was made to Treasury, hey, please give us information so we can talk about this thing on the basis of facts. And Treasury's representative gave an answer that wasn't satisfying to the committee's chair. So the request was made even clearer. 10 days, you have to do this. If you can't do this, we want a letter from the Minister, from Treasury, from the Director General. We want a letter explaining why can't you do this. And the fruit that came out of that request is information crucially relevant to this and to the broader policy debate in South Africa. So I wish that there might be a follow-up. The premiums, just mentioned, premiums discussed on that time. Those premiums, the cost of those premiums are not included in annexes A, B, C, or D in the information that Treasury provided. They're not included in the socioeconomic impact assessment. They're not included in any memorandum, extant or non-extant, accompanying this bill in terms of extra costs that come out of obligations provided for or discretion allowed to procurement officers in terms of the PFMA or other legislation. So, there's a big problem. There's a very serious problem that these premiums are not accounted for. And Treasury has shown, on the other hand, that it can really respond extremely quickly with great expedition to its credit when requests are made for information. The last available data in public in terms of what it did provide dated back to 2017, and it provided data all the way to 2024. So it really filled in the gap, and all that needed to be done was for it to be asked. So I sort of implore the committee to request that Treasury provide information on the cost of premiums that are currently being paid in order that we might better understand the kind of cost of premiums that would have to be paid under the Public Procurement Bill. Thank you.
There is a request from Mr. Ryder to check with COSATU if they want to have a bite. Mr. Parks?
Sure. No, I mean, we were sensitive to the time, Chair, but if you give us, a chance to pontificate, who are we to say no? I think the point that my colleague Simon had raised, I think cover the issues. We really, we support the objectives of the bill, but we just feel that it needs significant work, and obviously we are very sensitive to the extremely tight time pressure of the remaining few weeks of the NCP in the National Assembly as well. So I think our plea was basically to see what can we strengthen and fix now. We know it's a difficult order, but we think the bill is so critical that we fear unintended consequences if we don't fix it, for example, around Chapter 4 and so forth, especially around designation, the pricing, etc., localization, so forth. So we do feel if we rush it, we know it's not the fault of the Select Committee, obviously, but we do feel unintended consequences. And I think, Chair, also, given the impact of state capture and corruption upon the state, upon society, upon general businesses, we do need to elevate and strengthen it, and just the provisions around disclosure and transparency and so forth. So we are fearful, Chair, about rushing an unfinished product. So I think our plea also, Chair, was about to allow space, whichever route the NCP takes, to allow space for further engagement in NEDLAC, and even in the committee report to mandate Treasury to, for a supplementary bill, to go to NEDLAC, let's do some further work. I think government, business, and labor all have the same fundamental objectives of local procurement, of preferential procurement, and of also tackling corruption, etc. So I think, and then for us to come back to the 7th Parliament as well with a further supplementary bill. So yeah, I think that's it in a nutshell, Chair. Thanks very much.
Thanks a lot. Ms. Mamarekane, over to you, ma'am. Hello. Oh, members, I can't get hold of the chairperson, and I just spoke to Ms. Mamarekane now to draw the meeting to a close. Ms. Mamarekane, can you hear me? Maybe it's a network issue. Any member can close the meeting if there is nothing else to be discussed.
Sure, Nkululeko, thanks very much. I think it's we're at the end of the process, and I again want to just repeat the thanks that have come from all of us about the level and the depth of submissions that we've received. I think Treasury does have a substantial job ahead of them, and particularly in light of the comments about time pressures, etc. I think the chairman already alluded earlier on that the bill's been in process for over a decade, and to try and rush it now when it's only been introduced at the 11th hour doesn't appear to be very constructive. But of course, we'll go through our processes. I don't intend assuming the chair and making big changes to our processes. But just a last word of massive gratitude for the inputs and the encouragement that we've received. Positive comments as well from the IRR about the level of interaction with this committee. I think is well received. Thank you very much for that. We will convene again to get the feedback from Treasury. I believe that's next Friday. The notice will go out. Please, all of the presenters and entities that have presented, please ensure that you are involved again. You will get another chance to engage with the responses from Treasury, and we do look forward to those responses. And having said that, big thank you to the administration. I know this is always one of the tougher parts of the job when you're rushing around trying to get submissions processed on time, and I think that the volume of submissions here was a little higher than we're used to. Yeah, big appreciation to the team behind the scenes. Ladies and gentlemen, I believe that brings us to the end of the meeting. Nkululeko, unless there's any other announcement from your side.
The announcement, Chair, next week, Tuesday, we are having a meeting at 9 o'clock, a joint meeting to listen to PBO and FFC. That's all from my side.
That's fantastic. Thank you very much, ladies and gentlemen. Enjoy the rest of the day and have a fruitful weekend. Thank you and good day.
Thank you very much.